the state legislature. Assertion of accountability is a mirror image of the collective responsibility of the government to the legislature. The requirement of the trust vote fulfills that purpose in the present case. The present controversy has shone a light on the often fluid allegiances of democratically elected representatives. This is a matter for their conscience, and the court expresses no opinion on the matter. However, it is important to note that in directing a trust vote, the governor does not favor a particular political party. It is inevitable that the specific timing of a trust vote may tilt the balance towards the party possessing a majority at the time the trust vote is directed. All the political parties are equally at risk of losing the support of their elected legislatures, just as the legislators are at the risk of losing the vote of the electorate. This is how the system of parliamentary governance operates, and the learned senior counsel on both sides of the dispute congenially admitted that the outcome of the trust vote is the ultimate litmus test for the legitimacy to govern. However, we note that where the evidence indicates that circumstances of violence and coercion exist that would undermine a free and fair vote in the assembly, the governor and the court must take measures to ensure that the sanctity of the trust vote is maintained. In the circumstances as they have emerged in this case, the exercise of the authority by the governor was based on circumstances which were legitimate to the purpose of ensuring that the norm of collective responsibility is duly preserved. There existed no extraordinary circumstances for the governor to determine the trust vote was not the appropriate course of action on 16/3/2020. A significant ground of attack by Dr. Singhvi, learned senior counsel appearing on behalf of the speaker, on the decision by the governor to call for the trust vote is that convening a trust vote at this stage will impinge on the discretion of the speaker to determine whether the resignation should be accepted under proviso to section 190 subclause 3 subclause B, and at the second level to decide upon the consequences of the resignation in terms of anti-defection provisions of the 10th schedule. Short-circuiting is the phrase which was used by Dr. Singhvi. Implicit in the submission is the charge that holding a trust vote impinges upon the discretion of the speaker on whether to accept the resignations and to decide whether these members have incurred the wrath of disqualification. While analyzing the submissions articulated by Dr. Singhvi, the cobwebs need to be cleared. Governor does not decide whether the resignations that were submitted by the members were genuine and voluntary. That is squarely a matter which lies within the domain of the speaker. Similarly, whether a member of the House has incurred disqualification under the 10th schedule is a matter where the speaker is the designated authority. Conscious as the court has been of the fact that these are matters which lie within the domain of the speaker, in the recent past, a direction to the members to appear before the speaker and for the speaker to take a decision immediately was recalled by a three-judge bench. Dr. Singhvi alluded to these orders. It is straight law that neither the governor nor for that matter this court has the power to impinge upon the authority of the speaker to take a decision on the above issues. The issue, however, is whether the convening of a trust vote has to be deferred until such time as the speaker has taken a decision on whether or not to accept the resignations, and if so, the consequence of the members departing from the fold of the party on whose ticket they were elected under the 10th schedule. Holding of a trust vote operates in a distinct field from the issue as to whether one or more individual member of the Legislative Assembly have embarked upon a voluntary act of resignation or have incurred the wrath of 10th schedule. Holding a trust vote is necessary to ascertain whether the Council of Ministers, headed by the Chief Minister, has the confidence of the House. The continuous existence of the confidence is crucial to the legitimacy and hence survival of the government. It is a matter which can brook no delay, since the authority of the government presided over by the Chief Minister depends on the Council of Ministers continuing to have faith of the legislative body as a collective entity, particularly where the members resigned in an expression of the lack of faith in the existing government. The convening of a floor test is the surest method of assessing the impact of resignation on the collective will of the House. The consequence of acceptance of resignation is to reduce the numerical strength of the House. Until the resignations are accepted, the members who have resigned continue to be reflected in the strength of the House, having regard to the language which has been employed in Article 190, subclause 3, subclause B, shall thereupon fall vacant. Whether in a situation such as the present, an elected government is entitled to continue despite the resignations of 22 of its members has a significant bearing on the issue of confidence. Neither the governor, nor for that matter, the court can entrench upon the power of the speaker, but the pendency of the proceedings before the speaker cannot be a valid basis to not have the confidence of the House in the government determined by the convening of a floor test. Added to this is the factual circumstance in the present case that the Speaker Speaker accepted the resignations tendered by 6 of the 22 members on 14/3/20. All of the members sailed together. No explanation was forthcoming in the submission of Dr. Singhvi on what, if any, was the distinction between 6 members whose resignation were accepted with alacrity and the remaining 16 on whose resignations no decision has been taken. None of the members who resigned, neither the 6 or the 16, appeared before the Speaker. Therefore, non-appearance before the Speaker is evidently not a ground of distinction. We have highlighted the above factual scenario only to emphasize that the convening of a trust vote is of crucial importance to affirm the fundamental values of the Constitution, namely abiding by the rules which govern a parliamentary democracy. The fundamental precept of parliamentary democracy is that the government owes collective responsibility to the legislative assembly, and as a collective body, the legislative assembly is entitled to hold the government to account. The ultimate expression of accountability is the existence of or lack of confidence in the Council of Ministers. We are therefore unable to accept the submission of Dr. Singhvi that the holding of a trust vote would short-circuit the jurisdiction of the Speaker on a matter of resignation and disqualification. So, my lords, I just halt here for a minute. Your lordships dealt...
Before that, read para 82 also.
82, yes. During the course of his submission, Dr. Singhvi fairly accepted that the holding of a trust vote at this stage would ultimately only affect the ability of the resigning members to accept ministerial office in a new government, and that may be formed if the issue of disqualification has not been addressed in the meantime. Dr. Singhvi submitted that the effort in such cases is for resigning members to bring down a government on the allure of ministerial positions in a succeeding government, as their disqualification may not be accepted in future if the government were to change. This, as Dr. Singhvi submitted before the court, is how democratic politics operates in reality. The point of the matter, however, is that nothing prevents the Speaker from taking a decision either on matters of resignation or disqualification despite convening of a trust vote. That Speaker has not yet done so is not a ground to defer the convening of a trust vote. My respectful submission is that these two submissions are not being made for the first time before your lordships, that immediately when the government is formed, a trust vote should only be held then and not later, and that if there is a disqualification pending, there should be no trust vote. These two submissions and arguments were categorically taken in Shivraj Singh Chauhan and categorically rejected in there. Because, my lords, ultimately, please see, who are we dealing with in this matter? We are dealing with three distinct constitutional authorities. We are dealing with the Speaker, who exercises and is the sole authority to exercise jurisdiction under the 10th schedule. We are dealing with the Governor, who's the sole authority to decide whether there should be a floor test or not. And we are dealing with the Election Commission, which under the symbols order, read with Article 324, is the sole authority to decide whether within a political party, a rival faction or a splinter group, as they say, has emerged or not. Now, repeatedly saying that there has been a split and you have not merged is of no consequence, because that is no one's case. I have never argued that I have split from the political party. We have never argued that we needed to merge with another parties. Those were defenses under the 10th schedule. Our consistent and continuous argument has been that we, within the Shiv Sena, represent the rival faction which ought to be recognized as the political party and has now been recognized as the political party in question in this matter. Now, my lords, if your lordships will recollect, and my lord the Chief Justice also put a very pertinent question to me yesterday, that could it be argued by someone to say that because you expressed your dissatisfaction with the government in question or the Chief Minister in question, you would incur the wrath of the 10th schedule ex facie automatically. My lords, your lordships in Yadurappa and those line of judgments have categorically held that merely because a dissent is expressed within the party that we have no faith in the government in power does not mean that you're acting against the political party and you do not incur the wrath of Article 2(1) subclause A. Because till 2nd of July, my lords, 2(1)B does not get triggered. Both the disqualification petitions till 2nd of July 2022 are based on para 2 subclause 1 subclause A, whether you have voluntarily given up the membership of the party or not. And there we have respectfully submitted that time and again your lordships have interpreted it to say that there must be overt specific acts, moving with MPs to say that we are joining someone else, merging with another party. Those are overt acts which are considered. My learned friend cited one judgment where they said in the context to say that withdrawing support would also amount to the same. But please see the series of judgments, what they say. Yadurappa categorically says that merely because you go and say, I have no faith in the chief minister. In fact, there it was the chief minister. In our case, we don't even say that. Our case was not that we did not have the faith in the then chief minister to continue with the government. Our argument was that you cannot continue in the government in an MVA coalition with the NCP and the INC. Because, my lords, our resolution of 21st of June 2022 categorically said that your pre-poll alliance was with the BJP. Your post-poll alliance in this era of competing ideologies is with a person and a party with whom we've had serious differences for decades. And there is a vast discord and discontent amongst the cadres of the political party and the workers of the Shiv Sena. And thus we said that this is a case where there is internal dissent within the party. So right till 2nd of July 2022, it was only a case of 2(1)A, which Yadurappa squarely covers and says that merely because you express internal dissent, which is the essence of democracy, it cannot be treated to mean that you have voluntarily given up the membership of the party under 2(1)A. As far as the whip issue is concerned, my lords, which is a 2(1)B issue, on 21st, there was a whip appointed by us. They reiterate their faith in another whip. Both give their own categorical direction, which only comes into action on
You appointed your whip
on the 21st of
There was
June.
already an existing whip, right?
No, Maharaj, there was an existing whip, but when overwhelming legislation, and I'll come to that, Maharaj, I'll just develop that argument.
So that we are flagging for you to answer that whip arising out of a legislative party, not the political party, that you answer.
Absolutely, my lords, I have, because that's one of the issues also framed by your lordships, and when I deal with the issues, I'll deal with that as well. But it's important, my lords, let me just revisit some of the timelines, my lords, because a lot has been said on these timelines, and it's important for your lordships to keep in mind these timelines. Just go that one. My lords, it is our contention kept it in the place lock folder. Yes. Abhi nahi. May I? Well, it is our contention, and now I'll just go through some of the important dates, just 7 or 8 of them, my lords, to say that the very act of filing a disqualification petition was in fact an attempt to stifle dissent in the party. After a resolution is passed and we express no confidence in the deputy speaker, suddenly a disqualification petition is filed. So our respectful submission is that 10th schedule cannot be used to stifle dissent within the party. And definitely internal dissent does not amount to voluntarily giving up the membership of the party under Article 2(1)A. So, my lords, leading up to the 2019 elections, my lords, there was a pre-poll alliance between the Shiv Sena and the BJP.
So those timelines you're reading from somewhere, or
Well, these are just 5-6 dates I jotted down. I'm so sorry. I just jotted the relevant dates.
No problem. You can, why don't you give us those dates so that we'll first take down those dates and then you can make your submission on that.
Yes.
If you can just give us those dates straight away and then you can make your submission.
I see, Malad. And what I'll
We can
also
then,
do, what I'll also do by the end of the day, I'll have a page typed out. I should have done. I didn't get the.
But you can straight away just 5 dates so we can take
Yes,
it down.
yes, 5 or 6 days. Malad.
Just
So
tell us those dates.
21/6/2022,
Yes.
22/6/2022.
What happened on 21/6?
Well, I just should I?
Oh, you are giving
No, whichever way your lordship
No,
wants.
that's
Should
okay.
I?
It's well, what-
I'll go.
Easier to type it out if
Yes.
you say 20.
No, Malas, I must confess, I thought your lordship said first give the dates, then explain what happened.
No.
So I'll just give with the event that happened.
said, obviously,
Yes, I'm very.
that's what.
grateful. Very grateful. So, my lords, on 21st of
It's easier to type it out.
on 21st June 2022,
Yes.
the first meeting of the majority of the Shinde faction of 34 MLAs takes place. "34 MLAs were present in this. Mr. Gogavale was appointed as the chief whip, and Mr. Prabhu's appointment as the whip was cancelled with immediate effect.
This chief whip was appointed by the legislative party.
Malad, that
Just-
yes, park it. I'll show to your lordships that this is not only the convention, this has the authority of the political party. So this whole argument that this is only the legislature party and not the political party, I'll demonstrate that. That is how it's been right through. This whole artificial distinction which has been drawn that it is the legislature party who did it and the political party had nothing to do with it, I'll come to it. That's a specific issue.
Let's go through the dates. Give us the dates so that then we can then focus on that.
Yes, my lords. So
Dates and event, I mean, whatever.
Date and events, my lords. So on 21st, my lords, Mr. Gogavale is appointed as the chief whip. Mr. Prabhu's appointment as the whip is cancelled with immediate effect. And a resolution is passed which categorically provided that there is enormous discontent amongst the cadres of the party for forming a government with NCP and INC, who are ideologically opposed to the Shiv Sena. The resolution also said that the act of entering into a coalition had a tremendous negative impact on the voters and the party cadres at large, and that there was hue and cry towards the party leaderships for the act of aligning with the opposing parties. And then it categorically says that the MLAs as well as the leaders and workers throughout the country are facing a lot of humiliating questions on this count. So this is what we did. On the same day, the minority faction within the party, which at that stage was 24, now is of course less than 14 or 14, whatever. 24 of them on that day,
On 21st June itself.
21st June itself, met and passed the following resolutions. 1, removing Mr. Shinde as the leader of the party, because Mr. Shinde also had been a leader since 2019 of the legislature party. So they removed Mr. Shinde as the leader of the party, and they appointed Mr. Ajay Chaudhary as the leader of the legislature party. The resolution also recognizes Mr. Prabhu as having been appointed as a whip previously. On 21st itself, my lords, a notice was also sent by the majority faction, that is the Shinde faction, for removal of the deputy speaker. This notice was issued on behalf of and signed by 34 MLAs of the Shiv Sena Legislative Party.
Deputy Speaker. Remove him.
So is it not therefore clear that on the 21st, there are two clear factions. One, you claim that, well, there were 34 with you. And the others say that, well, there are 24. The 24 says, look, we are reiterating.
21.
21.
21.
21.
It's 55, so it's 21.
Right, 21.
Not 24.
Not 24, 21.
21. Now, on 21st itself, the deputy speaker communicates to the minority faction that they have accepted Mr. Ajay Chaudhary as the leader and does not respond to our.
Come again?
On 21st itself,
Yes.
the deputy speaker or the undersecretary of the Maharashtra Secretariat communicates to the party that they have appointed Mr. Ajay Chaudhary as requested by the minority faction and does not respond to our communication at all. On 22nd of June 2022, a notice is given by the minority faction to attend an emergency meeting on the same day at 5 p.m. And the notice said if you fail to attend, it will be deemed to indicate your clear intention to voluntarily give up the membership of the party. That's been their only case of voluntarily giving up the membership
To
of the
attend a
party.
meeting on
22nd of June 2022.
same day. Meeting is to be held on?
My lord,
Same day meeting.
yes, on the same day at 5 p.m. At 5 p.m. On the very same day, my lords, on the very same day, the majority faction writes to say that Mr. Prabhu's letter stating, calling for a meeting, he had no authority to call for a meeting, and therefore the notice is invalid, as he had been removed from his position as the chief whip.
No, rights to?
The majority faction replies to Mr. Prabhu's notice because he had called a meeting the same evening of the minority faction. He was part of the minority faction, issued a letter calling for an emergency meeting at 5 p.m. on the same day.
It stated that he had no right to.
Because he had been removed on 21st as the whip by the majority faction. On 23rd June, the first disqualification petition on 23rd June, the first disqualification petition is filed before the speaker, before the deputy speaker against 16 MLAs by Mr. Prabhu on the grounds that they had voluntarily given up the membership of the party to attend the meeting as they did not attend the meeting on 22nd.
First disqualification petition is filed before the Deputy Speaker
On the grounds,
by Mr. Prabhu, no?
that's right.
That they had voluntarily given up membership.
Was your notice to the speaker for removal of speaker given?
On 21st of June 2022,
So therefore, that's one first date which you have.
prior in time.
That date hasn't come. So 21st is the notice given by your group for removal of the speaker.
Of the Deputy Speaker. Because there was no speaker for the removal of the Deputy Speaker.
21st itself.
Yes.
So that 21st is cancellation
not
of
validation.
Prabhu's appointment as a whip and for also the removal of the Deputy Speaker.
It, my lords, has first Mr. Gogavle appointed as the whip.
Right.
Mr. Prabhu cancelled with immediate effect.
Right.
The resolution that there is widespread discontent passed on the same day.
That we took.
And also the separate notice issued to the Deputy Speaker.
Yeah, that you're right. No?
It's not part of.
Separate notice for removal the Deputy Speaker.
Notice for removal.
Under Article 179C. Fellows, may I? Now on 25th of June 2022, disqualification notices are issued to 16 MLAs by the Deputy Speaker, asking the MLAs to file their replies by 5:30 p.m. on 27th June
Just
2020.
before that, 23rd June, the first disqualification petition is for how many people?
For 16.
16 MLAs.
Okay.
What is their argument?
Yes.
Then the next one was 25th, no, you said?
Yes.
25th.
25th, disqualification notices issued to the 16 MLAs by the Deputy Speaker, asking them to file their replies by 5:30 p.m. on 27/6/2022. And 26th and 27th were the weekend. So these two non-working days are given to file a reply.
26th, 27th. Which one is to call?
25th is when they are given a notice to file their reply by 27th.
By 20.
So intervening are two non-working days, which are 26th and 27th are both non-working days. It's the weekend.
Right.
Now, on 25th, it's an important event, my lords. Even the Thackeray faction writes to the Election Commission. The minority faction writes to the Election Commission. So they go to the Election Commission to say that there is a rival faction which may set up a political party. And we are the Shiv Sena. They write to the Election Commission, invoke the jurisdiction of the Election Commission. And that order is not the subject matter before your lodges. The EC order which your lodges are dealing in another matter where I've been recognized as the political party categorically says that this rival factions had emerged on 21st and maybe was the culmination of dissent for a long time, culminated in the resolution of 21st of June 2022. It is in this background, my lords, that on 27th of June 2022, we come to this honorable court to say that A, there has been a serious violation of principles of natural justice, because instead of the scheduled period of 7 days, a 2-day period over the weekend is provided to us, and we need more time to file a reply. We also argue, Nabam, and I've repeatedly said so. I'm not for a minute ever suggested that we did not argue, Nabam. We also argued, Nabam, to say that quite unlike the cases of Kyoto, and this was heard at length, where it says that you will not interfere at an interim stage, Nabam, which is much later in time, takes note of it and says, but where there is a petition pending for the very, it would be constitutionally and for him to continue, he can always in the meantime prove his majority on the floor of the House and then continue with the disqualification petitions, because as Justice Mishra in detail said, that no harm is caused. At the earliest prove your majority, you can lay down the timeline, show that you have the confidence and proceed with the disqualification, but the reversal would be disastrous, because you would then set the pool and composition of the House to suit yourself so that no one can remove you in the meantime. And those entire arguments that your lordship had heard on 14 days, 7 days, etc., would be utilized, and that has to be seen, the then members have to be seen in the context of the notice on the date which was given to you. Your conflict of interest starts on that date when the notice is given to you. And you would utilize that time. And this is what Justice Mishra dealt with in that judgment in Nabam, to say that look at the reverse. Nothing happens in the meantime. If you are, tomorrow you win the confidence, you come back and you win the confidence. But as far as the other party is concerned, it's lost an opportunity to vote against you. Now, my lords, after this, it was keeping this in mind, after hearing arguments of this, the court consciously still only extended, did not injunct the speaker, gave time till the 12th. And of course, my lords, we had also in this raised as a justification for coming in an Article 32 to the Supreme Court was that there was a threat to our lives, homes are being burned, and we read out the press statements of Mr. Raut and others and saying that you'll see a series of dead bodies coming, etc. And we said it's not safe for us to go. And that is why we are out of the state. So these were the principal 3 grounds that we came on. The court consciously on that day said only time is extended, because the period provided as per us was 7 days, which was not complied with. On 27th of June 2022, the second disqualification petition is moved. This time against 22 or 22. Against 22 MLAs is filed by Mr. Prabhu.
That's also 27, is it?
27th, 6, 2022.
Yes, how many MLAs?
22.
From the speaker.
Yes, sir, from the
Till date, my lord, subject to correction, I am instructed to say that no notice has been received or was received, unlike in the case of the first 16, by any of the people against whom disqualification was alleged.
Out of these 22.
Against these 22. On 28th of June 2022, leader of the opposition, Mr. Fadnavis, went to meet the governor and requested him to hold a floor test, as the coalition ministry had lost the confidence of the House.
Sure. Well, may I just say one thing on this second, it's very important, for reasons I'll point out later, that as far as the second disqualification is concerned, allegedly on 27, first, as my learned friend pointed out, there was no notice. But for the first time, the disqualification petition of the remaining 22 MLAs is concerned, is only on the 8th of July petition. Up to 8th of July, it is never alleged that there was any disqualification petition pending. In fact, in all the governments, as I'll point out when I come to it, in all the governments, in every pleading, it has always been said that there are only 16 MLAs disqualified. On the 8th of July, when they filed a petition in this court, for the first time they alleged that there was a 27th July notice or petition for disqualification of 22 MLAs. Actually, the factual matter is There has never been any disqualification petition, to my knowledge, filed till 8th July.
Now, on
Yes.
28th of June 2022,
That's when the leader of the opposition meets the governor and seeks a
the
floor
leader
test.
of the opposition, yes, meets the governor. My Lord, the Chief Justice is absolutely right. And the governor then issues a communication on 28th June 2022 to Mr. Thackeray, directing him to face a floor test on the 30th of June 2022.
So both events of the same day.
Yes, yes. And as I had read out the letter to your lordships yesterday, it specifically refers in detail to three things. One is 7 MLAs who are part of the government, including 2 ministers, withdrawing their support. The letter of the leader of the opposition saying that it has lost its majority, and the resolution of 21/6/2022 passed by 34 of the 55 MLAs saying that there is a huge discontent within the party. And he calls upon Mr. Thackeray to face the floor test on 30th. Now, immediately after that, on 29th of June 2022, Mr. Prabhu files a writ petition before the Supreme Court seeking a stay on the direction calling for the floor test. On the ground that disqualification petitions of 42 MLAs was pending consideration. A floor test should be held the moment, and the words used in Bomai by your lordships are, the governor as the constitutional authority is entitled by any means or process. The words used are by any means or process in para 121 to say, to come to a conclusion that this necessitates a floor test. So when your lordships put that question to me yesterday, my respectful submission was that what else is a governor expected to do? He's not concerned with the 10th schedule, legislative party versus political party. His only concern is, does the government enjoy the majority on the floor of the house or not? Now,
Have you completed the dates? These are the.
sorry, I digress. Let me complete the dates.
Just complete the dates so that.
Yes, my lord. So the court then says the floor test of 30th, and categorically only says the floor test of 30th is subject to the outcome of the proceedings. But that floor test on 30th never happens because on 29th, Mr. Thackeray, within 10 minutes of this stay being refused, resigns as the chief minister. On 30th June 2022, my lords, Mr. Shinde and Mr. Fadnavis approached the governor as a coalition staking claim to form the government. And on 30th, the governor swore in Mr. Shinde as chief minister and Mr. Fadnavis as deputy chief minister, and directed the new coalition to prove its majority on 4/7/2022.
They are sworn in on the 30th itself.
Yes, my lords.
Through the majority on the 4th.
Please, on the 4th. This is 30th first. Now, on 30th, even the minority faction claims that they sent a letter, which is, as per the Election Commission, received on 1st in their office, again bringing to the notice of the Election Commission, as they did on 25th, a change in organizational setup of the party, including Mr. Shinde's removal as the leader of the legislative party.
Mr. Kaul, will you repeat yourself?
Yes. So, lady, on 30th, even the minority faction claims, which, of course, as per the Election Commission, is a letter received on 1st of July, they write to the Election Commission intimating change in the organizational setup of the party, including Mr. Shinde's removal as a leader of the legislative party. He's not removed as a member of the party, but as the leader of the legislature party, is their letter. The purpose that I'm emphasizing is that both on 25th and 30th, they themselves invoke and go to the EC, knowing very well that for any dispute, intra-party is a dispute exclusively within the jurisdiction of the Election Commission. Now on 2nd of July 2022, Mr. Prabhu, purportedly acting as a Shiv Sena chief whip, issues a whip to the members of Shiv Sena legislative party regarding the election of the speaker and the confidence motion. As per us, on 21st, he stood removed. He had no authority to issue any such whip. On 2nd, he issues this whip, and this is the first date when their argument of 2(1)(b) of the 10th schedule emerges. Because till now, it's only 2(1)(a), voluntarily giving up the membership of the party while not attending the meeting. On 3rd of July 2022, at 12:01 p.m., Mr. Rahul Narvekar is elected as the speaker with a total of 164 votes. The same day, my lords, at 12:02, I'm going to show the chart. And the rival candidate only gets, I'm grateful to my learned friend, gets only 107. At 12:01, Rahul Narvekar is elected as the speaker with a total of 164 votes. On the same day, on 3rd July 2022, at 12:02 p.m., certain MLAs from the former MVA coalition issues a notice for the removal of Mr. Narvekar as speaker after him having won his election. And after this, on the 3rd itself, they file a fresh disqualification proceeding against all the 39 MLAs, purportedly for voting against the party whip regarding the election of the speaker. And this they now allege to 1B. On 3rd itself, my lords, Mr. Narvekar recognizes Mr. Gogavle as the chief whip and Mr. Shinde as the leader of the Shiv Sena party. Which in any case, as per us, on 21st, Mr. Gogavle was appointed and Mr. Shinde, who had been the leader since 2019, we had reiterated our faith in his country.
Yes.
Now, they thereafter also challenged Mr. Narvekar's recognition of Mr. Gogavle and Mr. Shinde before the Supreme Court, which is one of the petitions pending before your lordships. And this time on the ground on Nabam Rebia, saying that he cannot proceed with the disqualification as there is a petition against him for removal pending. On 4th of July 2022, the House reaffirms its confidence in the newly elected Speaker, Mr. Narvekar. So, my lords, on 3rd he wins. You again move after his winning. 2 minutes later, he again, the House reposes its confidence on the 4th. And on 4th, then, the confidence motion called for on the floor of the House, wherein Mr. Shinde's government proves its majority in the House. 164 for, 99 against. Now, for a minute, my lords, because there's been so much confusion as I'm reading this timeline, Please have this chart as well. It's important. Just hand over. I've had copies made. Sorry, because this otherwise will be an endless exercise on the numbers. Which, where is the second page?
It's behind zoning page.
आपको देखना नहीं चाहिए था. Well, I'm so sorry we've printed the. It's typed like this or not?
No.
What is it then?
In election.
On second, when Mr. Prabhu issued the whip, press whip,
Yes. Yes, my
on
lord.
2nd July,
Yes.
he issued the fresh whip.
Yes.
So according to he could not have because his whip was already removed on
Right.
21st June. That was with respect to the election of the speaker as well as the the trust vote on 4-7.
Yes.
Correct? So can it not
And
be
then-
said? No. Can it not be said that by issuing the fresh whip, correct, they have accepted the calling of the trust vote on 4-7?
Yes.
So you can very well your submission can.
I'm grateful.
They cannot challenge.
I'm grateful. I'm grateful.
Subsequent calling the trust vote on 4-7.
I'm grateful.
Otherwise, they would not issue the whip on 4-7.
I'm grateful, my lord. I'm grateful.
On 2nd
Lordships
July.
are right. Lordships are right. I'm grateful.
But just we wanted to, at least I wanted to know that it was with respect to both speaker election.
Yes,
as well
yes,
as
yes,
no,
yes, my lords. Yes.
trust vote.
Yes. Now, my lords, kindly have this chart. Now, first, my lords, is the election of the speaker, Mr. Rahul Narvekar, on 3rd of July, 2022. My lords, has that?
Yes.
Now, please see, this is, I've done the exercise, my lords, both with 42 and without 42. I've done both the exercises on both the speaker and the confidence. So first it says, my lords, voting in the election of the speaker so-and-so, including the 42 members against whom disqualification petition was pending. Now, please see, my lords, Shiv Sena 39, BJP 105, others 20, total votes received by Mr. Rahul Narvekar 164, total votes against Rahul Narvekar 107, absent members 16, total strength of the House 287, strength minus the abstain is 271, majority mark 136, votes secured by Speaker 164. Now please have the one, my lord, where we remove the 42. Shiv Sena 0, BJP 105, others 17, total votes received by Rahul Narvekar 122, that is 164 minus 42, total votes against Rahul Narvekar 107, absent 16, total strength 245, strength minus abstain 229, majority mark 115, votes obtained 122. Now please have, my lords, on the back of the page, voting on in the floor test of the government on 4/7/2022, including 42 members against whom disqualification petitions were pending. Shiv Sena 39, BJP 105, others 20, votes in favor of Eknath Shinde 164, votes against Mr. Eknath Shinde 99, abstain 24, total strength 287, strength minus abstain votes 263, majority mark 132, majority votes obtained by Eknath Shinde 164, against 107. Now kindly have where 142 are removed. Shiv Sena, so BJP 105, others 20, votes in favor of Eknath Shinde 122, votes against Eknath Shinde 99, abstain 24, total strength 245, strength minus abstain votes 221, majority mark 111, votes secured by Mr. Shinde, discounting 42 MLAs is 122. Now, my lords, I'll come to the issues and I'll proceed issue-wise, my lords, because I have to deal with, as my lords have said, not only each of those issues, but also the issue of legislature party versus political party. But my lords, just before that, there is one submission that I wanted to make, which is we are dealing with three constitutional authorities, my lords. An attempt is to confuse issues as far as the exclusive jurisdiction of each of the three is concerned. The governor, all that he is concerned with is, do you in a democracy have the confidence of the House or not? Now, what better way to test that confidence than a floor test? Having said that, I'm not for a minute suggesting that it's not subject to judicial review, or you can just ask for a floor test for the asking, and there has to be material, there has to be due application of mind. But when an overwhelming number of MLAs write to you for various reasons and say that the concerned government or the ministry does not enjoy confidence, what is wrong with the governor having taken the decision of just given the opportunity to the then chief minister to face a floor test, in fact, rather than dissolving or sending a report to the governor, an act which the Supreme Court repeatedly frowned upon by saying that there used to be a huge misuse of Article 356, where reports to the president were said dissolving the House. They said the first thing is let them face the floor test. What is wrong with it? That is one. Secondly, my lords, comes the issue of the Election Commission. The Election Commission, under the symbols order, decides on what the words used are splinter group stroke rival faction. Those are the words used in para 15 of the symbols order. This whole argument that I have split, I have not merged, is not my argument at all. I have never claimed a split. I am claiming a rival fraction within the party, which according to us represents the Shiv Sena and has now been recognized as the Shiv Sena. Because your lordships have held that ultimately when two rival factions emerge within a party, you can't recognize both, is what your lordships' judgments have held, because a symbol can't be split into two. A name can't be split into two. It ultimately has to go to one or the other rival faction. In this case, that's a separate petition, but the competent body has decided to say that I represent the rival faction which should be recognized as the political party. And that's a decision exclusively vested in the Election Commission, Sadiq Ali downwards, including on interim orders, including on deciding whether political majority, legislative majority, two to be taken together, what's the cutoff date, when disputes have arisen, what numbers will be seen. They say they're the only party, only body entitled to and equipped to deal with it. And
Mr. Kaul, for the purposes of the 10th schedule, it makes no difference as to whether the rival faction which has emerged claims to still be within the fold of the erstwhile political party or forms a new political party in the legislature. It makes no difference at all. Once the 10th schedule, the 10th schedule attaches a disqualification the moment you have a rival faction, unless you make out one of the defenses. And it makes absolutely no difference whether you are saying that, well, we are in the same party. We are only saying that we represent the same party. Here, all the dates you have given us make it very clear that there is a rival faction. From the 21st, 34 MLAs represent a rival faction. They say, well, we are the Shiv Sena. There was a great deal of discontent because you teamed up with the Indian National Congress and the NCP when you were ideologically opposed to them, that we had a pre-poll alliance with the BJP. Fair enough. That's their contention. But does that obviate the fact that this is a rival faction within the meaning of the 10th schedule and a split within the meaning of the 10th schedule?
I was just coming to that. That's why I said three different authorities, three different provisions. I'm not for a minute suggesting that 10th schedule has a bearing there at all as far as the Election Commission is concerned. The third issue I'll just touch on, my lord.
And you know, a split does not postulate that people who are party to a split leave the party. It may be that the people who split sometimes leave the party. But otherwise, the 10th schedule will also operate where a group of persons whether minority or majority, say that we belong to the same party.
Yes, my lords.
And though you've constantly said that, the Eknath Shinde faction was the majority and the Uddhav Thackeray faction represented a minority after the 21st, it makes no difference to the application of the 10th schedule as to whether who remains is in the minority.
Yes. Manoj, I'll now answer that. So, one, my lords, the governor, as far as the floor test, the election commission, which looks at everything, including the legislature party, the political party, which, according to us, are integral. You can't segregate them, and comes to a conclusion which rival faction or splinter group should be recognized as the party. Then comes the issue of the scope of 10th schedule. Now, my lords, as far as the 10th schedule is concerned, an attempt is being made to place before your lordships to say that this was only the legislature party, this was not the political party. And in 2(1)(b), what is mentioned is the political party and not the legislature party. And in Mayawati, your lordship said that it is not the legislature party, it's the political party, which is mentioned in 2(1)(b), and it can only be read as the political party. This is what your lordships are told. Now, my lords, I have never ever said that the two are different. Our argument right through has been that this decision of the legislature party has the authority of the political party, and the only interaction that a speaker has while deciding on whether 2(1)(b) has been violated or not is his interaction with the leader of the legislature party and the whip appointed. Because conventions have also shown, and I'll come to those specific Maharashtra Assembly rules have not been shown to your lordships. The members of the legislature party appoint the leader of the legislature party. The leader in turn informs the speaker about all posts, all designations, which necessarily implies also about the whip who's appointed and any change in that. Even when the defense of para 3 existed, there were only two defenses, para 3 and merger in 4. Even when the defense of para 3 and split existed, the Supreme Court in Rana said that the speaker cannot embark on any independent inquiry as to what has happened within the political party and a split within. He will only, for purposes of disqualification, take a prima facie view. In any case, that is today academic because para 3 is gone. Now, what will the speaker today look at? The speaker under 2(1)(b) will look at who has issued the whip. What is the direction? Now, as for us, the whip as on 21st is not Mr. Prabhu. And we are not obliged to follow any direction of his. We are not for a minute suggesting, in fact, our contention has been that the speaker cannot determine. Your lordships are absolutely right. The speaker under 10th schedule is not required to go and determine whether a political party is split or not. That is the EC's jurisdiction. All that they look at is which are the set modes. The set mode is a speaker doesn't embark on finding out in the lakhs of membership who is the political party, who was expelled, who was not expelled. His interaction is with essentially the legislature party. Now, the problem which comes in the argument of the other side is to say, no, the word mentioned is political party, and since the two are separate, you are only relying on the legislature party. That's not our argument. The symbols order, para 6 and 6A, categorically provides that even for the continued recognition of a political party, its vote percentage, its elected representatives, its elected members of parliament are all important to determine the existence and continuance of a political party. So when you say this is legislature, this is political, that's an artificial distinction you are drawing. According to us, that legislature party has the political authority of the political party. And that has been the convention right through. And I'll show two letters. One is on record, one is not. Every time that a whip is communicated to the speaker, it's the legislature party which communicates the whip to the speaker. So this argument which is sought to be made is that Mayawati said it's only the political party, you are the legislature party, thus you've incurred the wrath of 2(1)(b).
We see the rules of the Maharashtra legislature.
Yes, my lord. I'm very grateful for that. I'm very grateful.
Those rules are very, very important.
Yes, yes. Show me. Statute compilation, my lords, on
PDF page 4,
PDF page 4,
starting at 6.
starting at 6. Rule 2F.
Yes, sir. 2.
Right. And then I'll go to 15 and 6A and 6B later.
Page 4, compilation 1, page 6. First compilation?
Statute
First
compilation.
compilation.
First
Yes. Statutes.
Page?
PDF page 6.
What page?
PDF page 6, my lord.
6.
This contains the entire rules or only part of them?
The entire rules.
My lords, these are the entire rules I'm
Okay.
told.
Yes, entire disqualification.
You find the entire rules?
Yes, entire disqualification.
Yes, the disqualification rules, my lords.
Are these rules?
Because they were framed under para 8 of the 10th schedule. कहीं लिख के रखना.
Yes, PDF page. Starts there. Statute.
First, my lords, 2 subclause G,
Page 7.
page 7, my lords. Then I'll go to the earlier section, but first have 2 subclause G,
Member.
page 7. Member means, my lords, has that? Member means a member of the Maharashtra Legislative Assembly. It says nothing else. Now please have 2 subclause F. Leader in relation to a legislature party means a member of the party chosen by it as its leader and includes any other member of the party authorized by the party to act in the absence of the leader as or discharge the functions of the leader of the party for purposes of these rules. And now kindly have Rule 3, subclause 1. My lords, have Rule 3, subclause 1. May I, my lords?
Yes.
My Lord the Chief Justice, may I? Rule 3, information to be furnished by leader of a legislature party. The leader of each legislature party, other than the legislature party consisting of only one member, shall within 30 days after the first sitting of the House, or where such legislature party is formed after the first sitting, within 30 days after its formation, or in either case within such further period as the Speaker may for sufficient cause allow, furnish the following to the Speaker, namely, a statement in writing containing the names of the members of such legislature party, together with other particulars regarding such members as in Form 1 and names of designations of the members of such party who have been authorized by it for communicating with Speaker for purposes of the rules. And now kindly have Rule 3, Subclause 4. Page 8. Whenever any change takes place in the information furnished by the leader of the legislature party under sub-rule 1 or by a member under sub-rule 2, he shall, as soon as may thereafter, and in any case within 30 days from the date on which such change takes place, or within such further period as the Speaker may, for sufficient cause allow, furnish in writing information to the Speaker with respect to such change. So it's the leader of the legislature party who communicates, points out the designations, the posts, and the people who are appointed. And today, clearly within, two rival factions are claiming that their leader is the leader of the legislature party and the whip. Now, the Speaker at this stage, my lords, only goes by what the leader communicates. The Speaker, as your lordships have held, has no independent tools at his disposal to go and find out within a political party where lakhs of taluka, district level, party organizations, members, constitutions are involved. That is how he interacts. Now they attempt to get out of it by saying that you only had a meeting of 34 legislatures, so thus you're only the legislature party. So our contention is, says who? You decide on your own that I am disqualified under 2(1)A, you decide I am disqualified under 2(1)B, and without a speaker deciding on either of the two. And you tell the court that this is ex facie evident that you have lost your membership, you're hit by the 10th schedule, and so you should be declared disqualified.
So this Form 1 should include whip also?
Manoj, I'm not too sure whether it does.
All posts. All posts.
It does. It does. It does. It
Normally does. By
yeah, it does. It does. It does. Such members as in Form 1 and names and designations of members who have been authorized.
Who have been authorized by it for
communicating with the Speaker. So which includes, my lords, communicating in any form, including the views. Now please see.
Yes, the communication,
the two communications.
It talks about the Speaker for the purpose of these rules. These rules also relate to the
3(5).
no, disqualification.
My lords, now I have 3 subclause 5, where a member belonging to any political party votes or abstains from voting in the assembly contrary to any direction issued by such political party or by any person or authority authorized by it in this behalf without obtaining in either case the prior permission of such political party, a person or authority, the leader of the legislature party concerned, or where such member is the leader or as the case may be the sole member of such legislature party, such member shall as soon as may be thereafter, and in any case within 30 days from the date of such voting or abstention, inform the Speaker as in Form 2, whether such voting or abstention has or has not been condoned by such political party, person or authority. But today the limited issue before your lordships as far as the 10th schedule is, how does the Speaker determine it? They want today the Speaker to embark upon and decide what the EC is meant to decide. The legislature party, the political party, according to us, are not distinct. They are co-joint, integral, and organically connected with each other. That is,
the bar who's not gone paperless. So
may I with respect say, from the day this hearing has started, I've been praying that your lordships doesn't ask me this question. But finally it was inevitable and it is followed on me today. But your lordships can be reassured, I'm trying very hard. And I have this with me and I'm taking some classes and lessons in it, my lords. Give me some time, hopefully I'll be there.
Before the next CB.
For sure, my lords. For sure.
Fortunately, the Bar Council group don't contemplate disqualification.
Your other two colleagues have coped up.
Yes, yes, my lords. They are far,
Mr. Sibal.
far more able, my lords.
You have.
We've acted as
hours. I
Chief
put in
Justice.
some extra hours to learn. And what is now?
My lords, but in all fairness, I've read out a few judgments from this to your lordships. In fairness and in my defense, my lords, I've read out at least a few judgments from
All the
Like
navigation
in other
is being
matters,
done
he has
by-
no defense. Mullah.
The navigation is the navigation is being done by your junior. You have to also do the navigation yourself. That's also the essence of being paperless. You see,
My lords, your time is precious. If I start doing the navigation at the moment.
all right.
So if that is the layout, please see how have parties understood these rules in terms of communicating to the speaker. Now,
You also can, if you can show us some kind of a practice which has been followed.
yes, that's what I'm coming to. Yes, my lord, that's exactly what I'm coming to. So please immediately now have
This, Mr. Kaul, this only answers half of the contentions raised by the other side, only to show that these names will be forwarded by the leader of the house to the speaker.
yes. No, my lords, absolutely. When I deal with the issue, my lords, I'll deal with it squarely. Since the question fell from my lords, I just attempted to. किसकी? इसकी एक minute, just give. Have you got the letters?
Yes, sir. Yeah.
Have you got the letters? Given it? My lords, one letter is on record. This other letter I don't think is on record, my lords. We've just got copies made. And give one to the to the other side as well. Have you given to the other side?
No, just give.
Yes, there are more than 5.
Just.
Mr. Courtmaster, if there's an extra copy, could you return it? I need to give it to the other side.
Thank you.
Very grateful. Now, my lords, as late or recent as 6 July 2022, Mr. Sanjay Rao, as leader of the Shiv Sena parliamentary party, writes to the speaker to say, this is to inform you that Shiv Sena parliamentary party has nominated so-and-so as the chief whip in Lok Sabha in place of Srimati Bhavna Gavli MP with immediate effect. And also, my lords, the earlier letter, which is
Convenience compilation.
Convenience Compilation Volume 2,
Yes, 728.
PDF 728.
Yes. Convenience.
PDF 728,
Which compilation?
Volume 2.
Volume 2.
Page? 7 to 8.
PDF page 728.
That letter of 25th of November 19, Mr. Kaul,
Yes.
Yes, my lady.
which is already highlighted.
Yes, it was read out, but I now want to read it in the context of the rules. May I, with your lordship's permission?
Yes.
To the Honorable Speaker, Shiv Sena's newly elected MLAs meeting was convened at Shiv Sena Bhavan, Dadar, Mumbai on Wednesday, 31st/10/2019. The meeting was chaired by Shri Uddhav Thackeray, Shiv Sena Paksh Pramukh. All the newly elected MLAs of the Shiv Sena party unanimously resolved that all the decisions of today's meeting be decided by Shri Uddhav Thackeray and authorize Uddhav Thackeray to take all the decisions in the meeting. Thus, Shri Eknath Shinde and Shri Sunil Prabhu were appointed as Group Leader and Chief Whip of the Shiv Sena Legislature Party in the Maharashtra Legislature Assembly. The resolution passed in this regard as follows. Resolution 1. It is resolved in the newly elected MLA's meeting of Shiv Sena Party that Shri Eknath Shinde is appointed as the Group Leader of the Shiv Sena Legislature Party in the legislature. It is resolved in the newly elected MLA's meeting of the Shiv Sena Party that Shri Sunil Prabhu is appointed as the Chief Whip of the Shiv Sena Legislature Party, and then all the MLAs.
Who writes this?
This doesn't have a,
This is signed by all the MLAs.
but it has the signature of all the MLAs.
So it's collectively written.
Collectively written, I'm grateful, by all the MLAs. And that is why I said, my lords, to that question, Hima, that when we come under the 10th schedule, what you're seeking to do is today create a distinction which does not exist. We have never argued the legislature party is separate or the party under the 10th schedule 2(1) means only the legislature party and doesn't mean the political party. That's not our argument. It's always done through the legislature party, at least in majority of cases, my lords. It's never the party president who writes to the speaker.
The call. Please read para 1 of that, this communication. Para 1.
Shiv Sena's newly elected.
Yes. Shiv Sena's
Newly elected MLA's meeting
Correct.
was convened at the Shiv Sena Bhavan,
Correct.
Mumbai. The meeting was chaired by so-and-so Shiv Sena Praksh Pramukh.
Correct.
Right.
Now these 4 lines are very important.
Paksh Pramukh.
Because what was the resolution passed? It is only a communication, correct, of the resolution passed, correct? It was a communication.
Yes.
Correct? It is not that the leader is decided by the legislative party. Please read the next resolution.
All the newly
The
elected.
meeting was chaired by so-and-so, so-and-so. All the newly elected members of so-and-so unanimously resolved that all the decisions of today's meeting be decided by so-and-so, so-and-so.
But they authorize it.
My lords, I have right through said the legislature party has the authority of the political party to do so. I am not for a minute suggesting that that is not so. They have the authority to do so. The communication is through the legislature party and the speaker's interaction is through them. Doesn't mean the political party is not involved.
Naturally, the decision is always communicated, whatever is only by the legislative
Yes.
party and or the leader of the
Yes,
legislative party.
yes. Yes, that's all that I am saying. Now, my lords, let me straight away now.
Exactly. Somebody has
Otherwise, you will communicate.
Yes. Yes.
But the speaker is concerned, it is only the leader of the legislative party will communicate.
Absolutely. Now, my lords, when I come to the case law and distinguishing case laws, once I'm through with the rules, I'll distinguish Mayawati. Mayawati is in a completely different context, and I'll deal with that. Rana, Mayawati, all those line of judgment cited, I'll distinguish each one of them. But let me now, my lords, at least start with the issues at hand, which have been referred to your lordships. Let's kindly come first to the second issue because Nabam, your lordships have heard arguments at length. On Nabam, your lordships have heard arguments at length and I needn't trouble your lordships again until unless called upon. Please have issue B. And I'll go issue wise and deal with
B.
yes.
Where are you reading B from?
What are you reading?
Well, that can be
Where are
read
they?
from that order as well. I'll have
Oh, that's
order.
the earliest order.
Yes, yes. I'll just give it. I should have actually pointed that out.
Okay.
Order
Yes, the
compilation.
referral order is, my lords,
An order compilation.
23rd of August 2022.
Order.
It's there in the
Orders compilation.
orders compilation.
Dear 35th.
My Lords, orders compilation, PDF page 34.
Yes.
Start.
What's the meaning of should be inviting a decision?
That's the question. May I read out?
Yeah.
My Lord the Chief Justice.
Yes.
Whether a petition under Article 226 or Article 32 lies inviting a decision on a disqualification petition by the High Courts or the Supreme Courts, as the case may be. Now, my Lords, our respectful submission is
Lies inviting a decision.
possibly a direct. My Lord, I think the inference was that could your lordship directly decide it?
Well, the other side.
That is
Whether
my.
we can directly decide what
Yes.
the speaker should have decided.
Yes, yes. So, my lords, on that, our respectful submission is that this is in the teeth, the argument of the petitioner is in the teeth of Quixote, because ultimately, my lords, under the Constitution, para 6 of the 10th schedule, the speaker is the sole constitutional authority to decide the issue of disqualification. It is the constitutionally designated authority to decide the issue. And even the proceedings before the speaker have been stated by your lordships to be proceedings under 122 and 212 as proceedings of the House. And even the interference with such decisions, except for violations of fundamental rights or substantive or gross illegality of unconstitutionality, etc., ordinarily is not interfered, but not to say that it cannot be challenged. I'm not for a minute saying it cannot be challenged. Now, what your lordships are being asked to do is to bypass the entire constitutional machinery, not only for the speaker. Even earlier, an attempt was made as far as the Election Commission was concerned, which your lordships refused to grant stay and said, let the Election Commission take a stand on it and then let the petition come here. And that is why at that stage I had submitted that your lordships can't act as the court of first instance. These are coordinate constitutional authorities vested with exclusive and sole jurisdictions. Their decision attains a finality. Their decision attains a finality. These are restricted grounds of challenge. You can't today come to the Supreme Court and say the Supreme Court should decide this issue because according to you, these are extraordinary circumstances. And the entire machinery should be bypassed. So you decide I'm ex facie, I've incurred the wrath of 21A and 21B. The speaker is biased, nothing else remains to be decided. And thus under Article 32, the Supreme Court of India must act as the court of first instance. That is effectively what your lordships are being told in this matter to do. And which my respectful submission is, my lords, that quite apart from the Shriman Bala Saheb Patil case, where your lordships also held that ordinarily go in a 226 and then come to this court. That's another facet. But in any case, definitely not straight to any court, whether 226 or 32, and say that you decided as the court of first instance. Now, my lords, the same party also relies on Nabam when it suits them. But the reason we came in a 32 that's important today, my lords, is we came in a 32 because Quixote does not deal with the issue we canvassed, which is in Nabam, which is post-Quixote, where a 5 judges bench of this court, and which today still holds the field, says that it would be improper and inadvisable for a speaker to proceed, continue, or conclude a disqualification petition while his own disqualification is pending. It is for this reason that we came in a 32 to say that A, our lives were in danger, we couldn't go to Maharashtra. B, the speaker cannot assume jurisdiction. So to say that we are hit by Quixote, we were not hit by Quixote, and that's the distinction we drew. Whereas your contention is clearly hit by Quixote. Because in your case, you're wanting the court to do something without the speaker even exercising its jurisdiction on the matter. Secondly, my lords, the speaker has won the confidence once, the House has again reaffirmed its faith. And we keep going back to the same argument to say that if that disqualification had been decided, then it would go back to the date what Justice Shah put to me yesterday. And I'll come to that argument. Well, even if a disqualification relates back to the date of the events, doesn't mean any action taken in the meantime gets annulled. In Rana, what your lordship said that when the speaker decides, he only looks at the events on the day the disqualification petition was moved, and at no event post that. That's what Rana said. But those series of judgments that your lordships have given on the point that there is no bar to an MLA or an MP till his disqualification petition is decided from participating in the proceedings of the House, because a constituency can't go unrepresented. He has to be there. Can't mean that all those decisions will be annulled, because the arguments ought to be raised that in the process, the trust vote, everything else will get annulled, and thus your lordship should restore status quo ante, because your lordships created and order created and toppled the government. That's the argument being made to your lordships. My respectful submission, my lords, is it's legally and constitutionally an unsustainable proposition. It's an unstatable proposition in law.
Disqualification under the constitution is vested in the governor.
Please, my lord.
Who takes issues of disqualification are vested in the governor, and he, if he chooses, takes the advice of the election commission.
Yes, that's 191(1).
Also, yeah.
And 191(2), as your lordship rightly said, is the speaker.
No, 192 talks about.
Yes.
It takes within its sweep.
Yes,
Just take.
my lords are absolutely right.
If any
Your lordships are
advises
absolutely
as to
right.
whether a member of the House clause 191(1), it will be referred to the governor.
Yes,
Governor takes
yes, yes.
In any event, decision of the speaker, the judicial review is only decision-making process, but asking the court to decide what the speaker is to decide is a leap.
Yes. Yes, ma'am. Absolutely. I'm grateful. I'm very grateful, ma'am. Now, my lord, would your lordships be kind enough to now move to the next question? Can a court hold that a member is deemed to be disqualified by virtue of his or her actions absent a decision by the speaker? Because my respectful submission is, how can the court ever deem an MLA to be disqualified pending a decision? Would that not necessarily circumvent the entire constitutional authority, my lords? And would the functioning of the legislature not be put in jeopardy by imposing temporary disqualifications? And would it not hamper electoral democracy that a whole constituency goes unrepresented? Especially when your lordships have time and again held that he is entitled to participate pending his disqualification. And it is sought to be argued that he should be deemed to be disqualified. Without the speaker exercising his jurisdiction or the governor in consultation with the election commission under 191(1) or 191(2), how can the court say that an MLA or an elected representative of the people is deemed to be disqualified till the decision is taken? It's like annulling the mandate of the people, my lords, and by the Supreme Court as the court of first instance in an interim order. Would your lordships be kind enough to have the next question? May I, my lords, with your lordships' permission?
Yes.
What is the status of the proceedings in the House during the pendency of disqualification petitions against the members? Now, my lords, right from Kuldeep Bishnoi Pratap Gowda Patil, Shivraj Chauhan, and Nabam Rebia, your lordships have time and again said that pending disqualification, he participates with all the vigor and robustness and legality as his command in the proceedings of the House. There is nothing which disentitles him for participating in the proceedings of the House. And can it be said that tomorrow, if he is disqualified, all those proceedings that he participated in
Article 100.
are null and void? Suppose there were decisions by his vote, a decision turned. So that will be annulled. Enough in this context to have Article 189 for a minute.
189 and 100 go together.
Yes. So, my lords, 189 is the mirror.
Assembly.
Great, great.
That's what I was saying. Sub-article 2.
Yes, my lords. My lord, the Chief Justice has?
Yes. Vedu.
Justice Shah has. A house of the legislature of a state shall have power to act notwithstanding any vacancy in the membership thereof, and any proceeding in the legislature of a state shall be valid notwithstanding that it is discovered subsequently that some person who was not entitled so to do sat or voted or otherwise took part in the proceeding. Quite apart from the provision, my lords, the law is laid down by your lordships. The moment your lordships permit and say that a MLA is entitled to participate, the necessary corollary is that whatever he has exercised in terms of his vote, the proceedings, tomorrow he votes in a budget. There are appropriation bills. There could be any other decision taken. So will we say that just because he's participated in a trust vote, your lordships are told annul everything? Because had he been disqualified, he could not have voted. And we have presumed he will be disqualified, or he's already incurred the wrath of 10th schedule. And thus the entire process is vitiated. That's the argument being made to your lordships, and that your lordships today should annul everything from the resignation, swearing in of a new government, speaker winning the vote of confidence, the government winning the trust vote. Everything should be annulled because everything was caused by your lordships' order, and your lordships are responsible for the toppling. Thus, only your lordships can correct it. That is the argument being made.
Which are the judgments?
My lord, the judgments are Speaker Haryana Vidhan Sabha versus Kuldeep Bishnoi, 2015, 12 SCC, 381, para 46 and 47. Then, and I'll also, my lords, later give the compilation numbers of it's part of the compilation. Then Pratap Gowda Patil versus the state of Karnataka, 2019. Volume 7, SCC 463, para 4 and 7.
2019, volume?
7, SCC, page 463, para 4 and para 7. Then Shivraj Singh Chauhan versus MP Legislative Assembly, 2020, volume 17, SCC page 1, para 79 and para 80. Then Nabam Rebia versus Arunachal Pradesh Legislative Assembly, 2016, volume 8, SCC page 1, para 188, 189, and para 191 to para 194.
Yes.
Well, that's quite apart that it is absolutely obvious from these judgments that retains the right to participate. Also see the danger, my lords. If such MLAs against whom the disqualification is pending and they are suspending during pendency of their disqualification petitions, it would open up serious possibilities of misuse of 10th schedule, and I'll give some instances. The participation, of course, gets affected. So you, in a way, fix the eligible voters who will vote in the House. And major decisions to which some of the MLAs could have been inconvenient do not participate now in. And also, my lords, a quick.
That's very clear, actually, a matter of first principle, because the mere pendency of the disqualification petition doesn't affect the status of the
And my lords, the moment your lordships have said they have every right to participate, quite apart from Article 180, that's the end of it.
That continues to be a
Even 181 also, Article 181. When the speaker against whom the discussion only in the particular meeting,
yes,
correct, he cannot. Otherwise, he can speak. Even that meeting also he can speak.
Yes, absolutely right. But my lords, this point, your lordships are absolutely right, is very clear, but it acquires some significance because the argument being raised is that if his disqualification, he is held to be disqualified, Rana says it will relate back to that day, and thus any action taken with his vote, with the crutches aid of his vote, stands vitiated and suffers from a constitutional sin. That's why I said it's important. Because your argument is that it relates back, and because it relates back, every vote given by him, including the trust vote, goes, and thus your lordships, an exercise of your lordships' extraordinary jurisdiction, must overturn everything that has happened and act as a court of first instance.
Absolutely.
Then, my lords,
Absolutely.
Would have a very serious consequence according to you. Suppose the budget is passed and he has participated and cast his votes.
absolutely.
If it is to be restored back, correct, to his original one, then all this budgetary provision, all this.
Well, I can't put it better. Absolutely. And that is what is being sought to be argued. And this is, Rana never said this. Rana is, when I come in, I'll distinguish the judgments. Rana is in a different context. Mayawati is in a different context, and you pick them up and apply them to a situation where they have no application at all. A line here, a line there, and you say that's the settled law on the point. Now, my lords, ground E, with your lordship's permission.
The member of legislators emolument act. There is a provision. Check up. What is the consequence of an MLA or an MP being disqualified upon his emoluments? There is a separate paragraph on that. Also,
My lord said
this
this
is
is
an
the
indication.
MLA.
Sorry?
Your lordship said the MLA emolument.
Emolument. Just check that up. There is a provision.
I will. I'll look it up. I'll look it up today. Now, my lords has ground E. Question E. Question E.
Relating back.
My lord, the Chief Justice.
Yes.
If the decision of a speaker that a member has incurred disqualification under the 10th schedule relates back to the date of the action complained of, then what is the status of proceedings that took place during the pendency of a disqualification petition? That's why, my lords, I put this, because that's been what they've been arguing right through.
Mr. Cole, D and E can be collected.
Yes. But the reason I'm laying so much emphasis on is because a large part of this argument, where your lordship's order of 27th and 29 becomes, according to them, the cause of all that has happened, only your lordships can rectify, and the solution lies in this because it relates back to that day. And because it relates back to that day, and trust vote also falls in between, everything should be annulled.
So will you explain on the basis of Rana and other judgment that they have cited?
Well, what I'll do is,
No, whenever.
I'll in one go explain each of those judgments, because I'll explain Brahmanand Reddy, Rana,
So you
Nayak, each one of them I'll distinguish
You will take up the judgments in one lot at the
in
end.
one lot.
All right.
Because, my lord,
Fair-
I have to cite my own judgments and I have to distinguish the judgments cited
All
by
right,
them.
fair enough. That should be
Relating
more
to
coherent.
relating back.
Sorry.
All this relating to relating back.
Yes. So, my lords, all those issues of Mayawati on political party versus legislature party in the 10th schedule, Rana status quo ex post facto, and the others, Manoj, as I go along, I'll deal with them. So, my lords, again, as far as this question is concerned, my argument remains the same as I just addressed your lordships on the previous. Yes. The law, the provisions of the constitution, it cannot be any other way. This is the only way it can be. Because the consequences for an electoral democracy are disastrous. Constituencies go unrepresented. No one is there just because the disqualification petition is pending. And he will not participate in, especially when your lordships, this is no longer res integra. Your lordships have ruled on it, on judgment after judgment. Now, my lords, would your lordships be kind enough to have...
That's why in the context of the judicial function we have developed the concept of the de facto doctrine. So even if the appointment of a judge is found to have suffered from an invalidity, that will not render all the judicial acts as invalid.
Absolutely. I bow down to it. I bow down to it.
Be clearer.
Now the next question is question F. What is the impact of removal of paragraph 3 of the 10th schedule?
Mr. Kaul, I have one small doubt. How are we going to deal with the situations which is emerging from time to time? Disqualification application is filed, speaker doesn't decide. And then the matter goes on. He participates in the assembly and a disqualified member continues. At what time and what is the time limit within which he needs to decide? Because till a decision is taken, disqualification issue is not decided, so therefore it's pending. This problem has been arising in a number of cases. Megha Chandra is one judgment where Nariman had to say that within a time limit he has to decide, but that's referred to a larger bench saying that you can't direct the speaker to decide.
And that...
But where are we going to
Well, your lordships are
deal with a situation like this, where speakers don't decide and events overtake that? And either matters become infructuous or the house is dissolved by flux of time.
The lordships are right. This will have to be considered. Should there be a timeline? Should there be a time-bound process? Should it be decided within a time-bound process or not? As your lordship said, that issue whether such a direction could be given to
Can you
the
just
speaker.
pick up that order where it's referred to the larger bench? That Megha
Just
Chandra
Nariman's
reference to
judgment.
larger bench. Can you just pick that up?
Yes. Yes.
I'll get hold of it, my lords. Let me just also apply my mind to this. It's fallen from my lords. But quite apart from the fact, my lords, when we were arguing Nabam, where we said that as far as the speaker's own removal is concerned, the assembly and the constitution itself provided a reasonably strict timeline on how it could be followed in terms of when the notice to be given, when is it to be decided. Possibly some kind of a timeline. As the lordship said, I'll have a look at the issue. Now, my lords, as far as the removal of the 10th schedule is concerned, my lords, firstly, this was only a defense against incurring a wrath under the 10th schedule. 3 and 4, para 3 and 4 are only defenses under the 10th schedule. That defense of 1/3 having split from the party is no longer available. But to me, it is wholly inconsequential because my case has never been that I have split or gone anywhere else. My whole argument has been that I represent the majority rival faction within the party. Neither have I given a support to any other political party, nor have I said I will not support a government as far as my own political party is concerned. As long as the coalition is something we've expressed our concern with, I've not gone anywhere. So this whole line of merger, split, it is not a case of a split, my lord. It's a case of a rival faction, or what the para 15 of the symbols order says, of a splinter group within the party.
What's the difference between a split and a
Split is
and split on the one hand and what you are suggesting?
the difference between the two is that split is an issue where you, as a defense, say that I will not incur the wrath of 10th schedule. I have not even voluntarily left the party. In the case of a rival faction, I claim that I am the political party and recognize me as the political party under the symbols order. Please have that symbols order for a minute. It's a question that your lordships have put to me, a pertinent question, and this will answer. Please have statute compilation, PDF page 155.
The fact that there is a
I seek your lordship's indulgence only for a minute, Lord. I seek this liberty only because I have to move an urgent application before my Lord Justice Shah, Chambers. No, no, just liberty to go to my Lord's chamber. That is all that I seek, Lord.
You Lordship be kind enough to have para 15 of the symbols order.
Statute compilation, PDF page 106.
Statute compilation,
Para
PDF
15 of?
10.
Sorry,
15 of, para 15 of?
symbols order.
Symbols order.
This is in the context of the same issue, right?
Yes,
Issue F.
same. We were at F, and also in the light of the question that my lord posed to me before lunch of split under 10th schedule vis-a-vis rival faction. I just needed to answer that, so I just need to show two provisions to your lordships. Para 15,
Page.
Where is that symbol order?
PDF 103,
Statute compilation.
statute
103.
compilation.
1. Statute compilation 1.
Yes.
103, yeah.
Okay.
Yes.
Yes.
With your lordship's permission. Power of the commission in relation to splinter groups or rival sections of a recognized political party. When the commission is satisfied on information in its possession that there are rival sections or groups of a recognized political party, each of whom claims to be that party, the commission may, after taking into account all the available facts and circumstances of the case, and hearing such representatives of the sections or groups and other persons as desired to be heard, decide that one of the such rival section or group or none of such rival section group is that recognized political party, and the decision of the commission shall be binding on all such rival sections or groups. Now kindly compare this, my lords, with para 3 of the 10th schedule as it existed. PDF page 50 of the same compilation.
What page is this?
PDF page 50.
PDF page 50, my lords.
50.
This is something else.
Yes.
Yes.
Justice Narasimha, is that? Yes, that's. Disqualification on ground of defection not to apply in case of split, where a member of a house makes claim that he and any other members of his legislature party constitute the group representing a faction which has arisen as a result of a split in his original political party, and such group consists of not less than 1/3 of the members of such legislature party. And now please have B. From the time of such split, such faction shall be deemed to be the political party to which he belongs for purposes of subparagraph 1 of paragraph 2, and to be his original political party for the purposes of this paragraph. So when you split and form a group, that becomes your original political party within 2(1)(b) and saves you from disqualification under 2(1)(b). Whereas under para 15 of the symbols order, within the party itself, a rival faction emerges, goes to the election commission and says, I am the recognized political party. And as your lordships have held, there can't be two recognized political parties within the setup. The symbol can't be split, the name can't be split. So either none of them get it or one of them emerges as the recognized political party within para 15 of the symbols order. Whereas here, after a 1/3 split, it calls itself. It's like saying if Eknath Shinde or Uddhav Thackeray, one of them had split and called themselves the Shiv Sena Thackeray, the other would have called themselves the Shiv Sena Shinde. The 1/3 split would have become the new original party. That's not our case. We've never claimed that we have a new original political party. Our political party remains the same.
This, as the first part of the section, a member of the House makes a claim that he or any other member of his legislative party constitute the group representing a faction which has arisen as a result of a split
In his
which is prior in point.
Right.
So what is the as a result of the split, in his original party.
Right.
Therefore, that must occur prior in point of time.
Right.
In the political party, there must be a split, the consequence of which will be recognized in the legislature.
Right, right. And you will call yourself the new original political party for purposes of 2(1)(b). Now, my lords, in terms of the question that I was addressing your lordships on, which was F, what is the impact of the removal of paragraph 3 of the 10th schedule? My respectful submission, my lords, is that a defense which was available is gone, is no longer available to disqualification under the 10th schedule. Only merger as a defense now remains. B, it doesn't concern me at all, because my case has never been, or never have I sought nor can I seek the protection, but it's not in the Constitution as a protective clause, nor has this ever been my case. My case is that I, as the faction within the party, represent the recognized political party. And my lords, when I come to the judgments, I'll show to your lordships that this issue, when it arose, and this in itself can never be a 2(1)(a) case either. Merely because a faction says that I'm the recognized political party and goes to the EC for a relief under para 15 of the symbols order doesn't mean he incurs disqualification under 2(1)(a) by saying that I've lost the majority. Because in Yadurappa, this was the exact case which arose. MLAs there went and said, we do not have faith in Mr. Yadurappa. And ultimately, the speaker disqualified them. The Supreme Court said that they have only said we do not have faith in Mr. Yadurappa. They have not said that they don't have faith in the political party or they formed another political party. And such the drastic step taken by the speaker to disqualify them under 2(1)(a) was far beyond what the facts necessitated in the facts of that case. So to say that merely because I go to the governor and I say that here today, given the ideology of the party, the overwhelming cadres don't want to go along with the MVA. Our entire contention has not been that the Shiv Sena should not form the government. At that stage, our contention wasn't even that the chief minister could not have formed the government with any other political party. Our lack of faith in the ministry was because you were carrying on with a party whose ideology did not match our ideology. We had been in loggerheads for very long. And going along with them was creating a huge discord and discontent amongst the cadres and party workers. Now, can this be treated? By this logic, my lords, any form of internal dissent, anyone raises any voice of dissent, which is the essence of democracy within a political party, would be said that he's incurred the wrath under 2(1)(a). And I'll show cases of 2(1)(a), what overt acts have been done in those cases. You go with another rival faction, you go there and say, I'm helping them form the government. I don't have any longer any faith in the political party that I belong to, which is ruling. Those are the kind of overt acts which are 2(1)(a) cases. Here, the only allegation against me at that stage was, you have not attended 2 meetings. In fact, at that stage, the allegation was only that you have not attended the 2 meetings which have been called on 21st and 22nd, and thus you have voluntarily given up the membership of the party, the first disqualification petition and the second disqualification petition, as on 2nd of July 2022. And then came the issue of whip, by when both factions had appointed their whips, leaders, all that dispute arose. That's a separate 2(1)(b) issue. So according to us, my lords, as far as paragraph 3 of the 10th schedule is concerned, A, had it been on the statute book, still, it's not something that I would have relied on. Because according to me, I am the majority, I constitute the recognized political party, and today I have an order also, which is the subject matter of another petition. But my whole case was that under the 15 of the symbols order, I am the faction which represents and ought to be recognized as the original political party. That was my case.
So what does the speaker do in such situations where you raise a claim that you are the political party?
Well, the speaker is only concerned as far as involuntary membership is concerned. According to me, Malus, this does not constitute an act. Which
we are
on 2(1)(b),
case,
2(1)(b),
where under 10th schedule violation, they say that there is a violation of the 10th schedule, and you take the plea that it is not a case of a split, but it's a case of reorganization or realignment of the party, and I have the majority of the party. What is the speaker supposed to do there?
Yes.
What is the inference that he is supposed to draw?
So,
will he say that it is not a 10th schedule case?
my lords, what he will say in such a case is, and that has been our case, that his link is with the whip and the leader of the legislature party. That is why I read out those rules of the Maharashtra Legislative Assembly to your lordships, that the members elect a leader. The leader in turn informs the speaker of all the designated posts, the people who will hold various posts. And even when the 10th schedule existed, in Rana's judgment, the Supreme Court said the speaker cannot embark on an independent inquiry to find out whether there has been a split within the political party at all. Even the prima facie view that he forms, even when 3 was there, was only on the question of prima facie there's been a split. Today, the split is an inconsequential issue because para 3 is not there. Today, the question is of a rival faction and under 2(1)(b, not obeying the orders as communicated through the whip. Now, not communicated by the whip is the issue of which whip do you follow. Now, if the majority of the members of the legislature party with the political authority of the political party appoint a leader and appoint a whip, naturally the speaker will be in touch with that whip.
Your answer is that speaker has no option except to go by the majority of the legislature.
Rule of majority as far as the legislature party for
the context of a 10th schedule.
In the context of 10th schedule.
Only majority.
Majority, and but the mistake which is being sought to be made is to segregate a legislature party and a political party. That legislature party necessarily carries with it the political authority of a political party. And that is where, my lords, para 6A and 6B of the symbols order becomes important, because 6A and 6B of the symbols order both say that for the continued recognition of a political party, the vote percentage, the MLAs, the MPs are all essential for even a political party to survive and continue. So this distinction which is being drawn to say that you've only brought about something in the legislature party and you don't have the support in the political party is wrong. And the speaker's inquiry is limited in such a case. If the speaker could do the same thing which the election commission could do, then all those lines, my lords, where your lordship said even when para 3 existed, will not embark on an independent inquiry, will only take a prima facie view, whether 1/3 is split or not, because the speaker does not have the wherewithal, my lords, it's the election commission.
In other words, to simplify it, sorry for asking you repeatedly the question, leave aside their argument of drawing a distinction between political party and a legislative party, leave that aside. As you are arguing, the only method that the speaker can adopt in a case where somebody sets up a case of he garnering the entirety of the party is to just go by the number of legislators that he has, that group, that's all.
And be in touch with the whip and the leader of the legislature party as to what are the instructions.
Again, there is a problem because there are 2 whips.
Sorry, my lord.
There will be 2 whips.
Right.
So, in the teeth of 2 whips, the decision that he has to take is a majority decision.
Because, my lords, your lordships are absolutely right, because the rules say the members of the legislative assembly will appoint the leader. If the majority of the members of the legislative assembly appoint the leader, and that leader in turn is in touch with the speaker and communicates all the decisions to him, they are presuming that what is done there does not have the support of the political party. But there is no basis to say so, because they make the mistake of saying that the 2 are separate. And because the 2 are separate, you have done all that you had to do within the legislature party, but you did not have the support in the political party. What is actually proved is quite to the contrary, because today it is shown even by the competent constitutional body, which is the Election Commission of India, that I am the political party. The speaker's interaction, my lords, is with the whip, with the leader. What are the directions given? He will not embark in to find out what has been the political division in the political party. For that, under 15, otherwise, my lords, if that all could be done under 15A, under 15, the power for determining this very question has been given to the Election Commission, and your lordships have said is the exclusive jurisdiction. And the reason is because when that is done, talukas, districts, MLAs, MPs, percentage of votes, constitution, on the date when disputes arose between parties, what was the stated position of various factions, everything is taken into account. Then, my lords,
does para 15 of the symbols order also necessarily implicate a split within the meaning of para 3 of the erstwhile provision of the 10th schedule, or no?
No, my lords, no.
What does a splinter group mean in the symbols order? Vis-a-vis the split in 3, which is now being
Because
committed.
there are two rival factions
Within a
the
political
party,
party.
Yes.
who emerge. And both claim that we are we are entitled to be the recognized political party. So one of the two, who it is accepted, carries on with the party and the symbol. Then,
So, Mr. Kaul, since that order, just to understand, 15, once it applies and you say the EC's decided it, that's also perspective, right? It obviously can't, the clock can't be put back to what the situation was on 21st.
the EC says that the split, as I said, that order is not, it says that the split occurred on 21st, the rival faction emerged on 21st.
So it relates back to.
Right. And my lady, that's why I pointed out, even on the 25th and 30th, their side, for whatever reasons, on issues which were emerging or simmering within the political party, were already writing to the Election Commission, recognizing the authority of the Election Commission on 25th and 30th. I'll revisit some of those.
What you're saying is the pot was boiling, it's just that it was
In fact,
ratified by the
as
Election Commission.
yes, that's another issue I'll touch when I come to that particular issue. According to us, it was simmering for a while. It culminated in the rival factions ultimately by way of a resolution expressing themselves on the 21st of June, led to the events which happened, and ultimately a petition was filed before the Election Commission around the 18th of July. And even that order recognizes all this that started earlier. I don't have to
call para 15 does not expressly use the expression split at all.
Right, man. Right.
It doesn't-
I'm very grateful.
Just says which of the factions of the original political party represent the political party. That's the function of the Election Commission. Let's go back to para 15, because one needs to look at what is the relationship between para 15 to the erstwhile para 3.
Yes.
Rival sections.
The marginal note refers to splinter groups. The expression splinter groups is not used in the text of the provision at all.
Yes. Yes.
It says that the text says the rival sections or groups of a recognized political party, each of whom claim to be that party. Para 15 applies in a situation where you have different groups within a party. Each says, I represent the party. I am the Congress. I am the Shiv Sena. I am the BJP, so on and so forth. None of them have professed to leave the fold of the party.
Right.
So the Election Commission then has the power to determine which of those rival factions represents that party.
Right.
Now, para 3 operated in a very different realm. Para 3 applied in a situation where there is a split within a political party, in which case, provided you had not less than 1/3 of the total membership of the party, that would be deemed to be the original political party for the purpose of the House.
Manoj, may I just add to what your lordships are saying?
Right.
They 1/3 leaves. 1/3 leaves under the 10th schedule and says, now treat us as the original political party for purposes of 2-1.
Right.
That other political party continues.
And
The other political party continues from which they split.
so therefore, they're deeming fiction that therefore the 1/3 then is deemed to be the original political party to which the group belongs for the purpose of para 2-1.
And for their purpose.
Right.
Or taking any direction as far as they are concerned.
Para 3 has gone. Para 3 has gone.
Right, right.
Now, in a situation where the Election Commission recognizes under para 15 of the symbols order that one particular faction represents the political party, can this at all be within the purview of the 10th schedule then?
According to us, not at all, my lords. According to us, not at all. In all humility, I say so. And my lords, Right.
the acts of the person as a representative of a constituency vis-a-vis that of a person.
My lady,
party.
what happens is when you participate as an elected representative and vote on the floor of the House,
Can you draw a line?
you can't. Anything which comes up on the floor of the House where you exercise your right as an elected representative is saved. The Constitution says so, 189, and your Lordship's judgment says so.
Is saved, but the act per se of doing something which is not contemplated.
So you will lose, you will be disqualified. There is a difference. If ultimately some disqualification petition is allowed, that person will stand disqualified.
So disqualified for acts which were supposed to be done by a person as a member of the party.
So you are disqualified in your status as a member of the House, but your acts done during the pendency of the disqualification petition remain untouched.
No issues on that. But can you go beyond it and say that this qualification, he is, say, not abiding by the whip relating to the internal affairs of the party, would still, the clock would be put back to where it was.
So even if
Status quo
if
anyway.
the clock is put back,
Yes.
and he is ultimately held to be, suppose your lordships were to hold against and say that you did not follow the whip, you did not represent the majority of the party, and you have incurred the wrath of Schedule 10, the person concerned will stand disqualified. But to say that the consequence of that is that even before he was disqualified and an order was passed by the speaker, all actions that he participated in, which are as per the settled law by your lordships to say that he is fully entitled to participate in, will stand annulled, is wrong.
So you're saying it can't be sifted, the act done by a person.
Your lordships have time, and the Constitution says so, and your lordships have said that pendency of a disqualification petition is no ground to say that an MLA will not participate, and under various circumstances. It arose in the case of a disqualification petition pending. It happened in the case of resignation letters. It happened in the case of Nabam Rebia to say where a removal was pending of the speaker. They said you can't stop them from participating in the removal of the speaker merely because there is disqualification petition pending against them. And especially in Shivraj Singh Chauhan, Para 78 deals with these situations. You can't say because it was pending, thus it tilted in favor of one party. The court says these are matters which happen at any given timing of any vote for anything, trust or otherwise, someone will benefit or the other. But you can't trace it back to say, had we treated it on that day as disqualified, you would have not been entitled. Thus, any vote that you've given in the trust vote or anywhere else all stands annulled.
So the consequences will flow prospectively.
Yes.
Para 2(1)(a) of the 10th schedule can have no application, right? Because para 15 postulates that the claim is that I represent a political party, and the election commission will then decide which of the factions is representing the political party. So in a situation which is governed by para 15, there is no question of having voluntarily given up membership of the party, right?
That's what it comes to. In other words, a majority, then again it goes into the question of, but then in the facts of this case, the majority based on the para 15, as it turns out in the assembly, is based only on the legislators. So you have the majority of the legislators to support you in the legislative assembly, and therefore you can appoint the leader of the house, who can only give the whip. So therefore the question of anti-defection would not apply at all.
One, B, our case, absolutely right. And our case in addition is also that the decision which the legislature party took had the political authority also to take that decision. I'm going a step further. It is wrong to say the legislature party elects the leader. The legislature party, as the rule, brings and appoints the whip, conveys it to the speaker, but doesn't mean the political authority is not there. The problem is they tend to segregate the two and say you only had the majority of the legislative party. The EC says when we go through the whole thing, percentage of votes polled and the number of members you have is also a ground to recognize a political party, apart from the membership of the political party.
Mr. Kaul, para 2(1)(b) still poses a little bit of a problem. Forget this case. We are now analyzing it as pure doctrine. as I said, once a para 15 of the symbols order situation arises, para 21A of the 10th schedule can never operate, right? Because once you are deemed to be the political party,
Yes,
the question of
absolutely.
you having given them, even that faction which is not recognized as the political party, they have not voluntarily given up membership. That's a little complicated. We'll keep that aside. But para 21B still poses a problem because the order of the election commission is prospective, because it determines which of the two factions is the political party, right? If the order of the election commission is prospective, then we'll necessarily have to hold that though it does not date back to the defiance of the whip, once this is recognized as the political party, then para 21B will also not operate. Because if once your faction is recognized as the political party, then where is the question of a defiance of the whip? The defiance of the whip is of that political party, right?
And
so willy-nilly, it will impact. It may not be retrospective, the declaration by the election commission, but it will certainly have a retroactive effect in the sense that then there can't be a defiance of a whip, isn't it?
And then the question will arise,
Otherwise, it will be anomalous.
Then the question will arise, the speaker will look at which whip and which leader. But I'm sure my learned friend will have his chance to argue. Yeah, I'm sure you will. But all that I'm saying is that we very patiently heard you for 3.5 days. All that I'm respectfully submitting is that what is to be seen, and that is why what is to be seen is those three rules. The members of the Legislative Assembly appoint the leader conveys
that you have made a note.
Or designated post, and the whip, because, and that is why even with para 3 existed, my lords, and at the cost of repetition, I'm just troubling your lordships with it. Rana said, and I'll read those paras, the speaker can't embark on an independent inquiry into the affairs of the political party.
Mr. Skoll, let's do this. Now you've come up to issue number F. You can quickly go through G, F ke baad G aata hai na? GHIJ. So you can finish the 4 and then go straight to the judgments which we are. Now we need to observe the clock. There's no clock here, right?
Right there, actually.
Well, as we removed it. No, well, all that I'm saying is I'll need some time tomorrow. I don't think I can cover so much. An hour tomorrow. I'll need an hour.
We have to wrap up by tomorrow because we don't want to keep this parted beyond Holi. I mean, we have to finish this.
I'll go as fast as.
They take 2 hours.
Well, 3.5 hours plus 2, or 3.5 days plus 2 hours.
Where to wrap up today?
Yes.
And
Your colleagues.
Mr. Jethmalani and Mr. Maninder Singh all.
And SQ.
Malad, I'm trying my best to cover as fast as I can.
All right. So long as your side completes by 2 o'clock tomorrow, we are on schedule. 1 o'clock.
Now 1 o'clock.
In Bombay, we used to rise. Anyway, so we started at 11.
Yes. So, my lords, now next, kindly have what is the scope and power of the speaker to determine the whip and the leader of the House Legislature Party? What is the interplay of the same with respect to the provisions of the 10th schedule?
Yes.
Again, my lords, the submissions which I have already made, this whole presumption that a whip appointed by a legislature wing does not represent the authority of the political party is entirely misconceived. And it is misconceived, as I said, my lords, that you cannot segregate at the cost of repetition. 6A and 6B of the symbols order categorically provides that percentage, number of votes polled, MLAs, MLCs, members of parliament, all are part and integral and organically connected to a political party.
So how do you answer G then?
So my answer to G is that we will go back to the rules again, the Maharashtra Assembly rules. And the question is, What is the scope of the power of the Speaker to determine the whip and the leader of the House Legislature Party? What is the interplay of the same with respect to provisions of the 10th schedule? If under the rules, members are members of the Legislature Party, they appoint the leader. Naturally, the majority will appoint the person, whoever they do, will prevail over a minority appointing the leaders. Naturally, that would prevail by the simple rule of majority. And that leader in turn will convey the whip. Now, there to say that the Speaker will be directly in touch, will determine on his own, that's where Rana comes in. That you're not embarking on some independent inquiry. Your prima facie view is limited to the issue of disqualification. It says you'll take a prima facie view under the 10th schedule. A prima facie view, qua disqualification. But you're not embarking, like the Election Commission, on an independent inquiry into who represents, who's the whip of the party, who's there. The assembly rules provide. And the interface and the interaction of the Speaker is with the leader and the whip. And the whip is communicated by the leader. The leader can only be appointed by the members of the House.
Disobedience of the leader of the legislature to the speaker.
In fact, my lords, Rule 5, which I had, Rule 3, subclause 5 of the rules I had shown, specifically says that it's the leader of the legislature party who also informs about the disobedience of the
Rule 3 we saw.
Yes, Rule 3, subclause 5. Because I'm also now trying to rush through as much as I can.
3, 1 and 5.
My lords, as far as the 10th schedule is concerned, my lords, this may not be directly arising out of this question. But my lord, it's a serious question that you can effectively stifle in a party democracy, as happened here, because the resolution is passed on the 21st. On the 23rd, disqualification notices are given. You know, in the resolution of 21st, where people have said that we are not with this coalition continuing, naturally there is a good chance of a trust vote coming. Look at it the way it's always been said that this is how you'll hamper, harm democracy. The moment you know there is internal dissent, the moment you know you will not within the party be able to survive, an overwhelming majority is not with you. The easiest thing is, suppose there are 105 elected members. They know 100 here and the overwhelming cadre of the party are not with them. 5 of them go and file a disqualification petition. And that disqualification petition is not decided by the Speaker because there's no timeline, unlike the removal of a Speaker where there are timelines under the rules provided for. And he keeps sitting on that. So a trust vote, which ought to happen immediately, and a government which has gone into minority, or a ministry which does not any longer enjoy the confidence of the House, continues because there can be no trust vote. Because what was sought to be argued was that a trust vote can only be when the government is formed and not later. So the abuse of that is enormous. And that is why this was a reason in Nabam Rebia, my lords, when Justice Mishra dealt with that issue. And I keep coming back to it to say that let's balance the two and see. A Speaker can definitely, in such a situation, wait with the disqualification. He should be keen to immediately establish his majority and then take up disqualifications. Because if an MLA misses out on the vote or an MP misses out on the vote to remove the Speaker, there is no second chance on that. There's no judicial review of that, but there's a judicial review of disqualification, which can happen. And he specifically dealt with it in para 248. This very issue. Then, my lords, and again, as far as the party is concerned, the Election Commission order is there. There they've already said that there were no even internal routes available for dissent. That we are arguing in the other petition which the petitioners have filed. The Election Commission has said we've gone through the Constitution. How does someone dissent here? How does someone express its dissent in a matter like this? You've left nothing. The same party president is elected by a body, which is the Electoral College, and he appoints the Electoral College, which is there the subject matter. So ultimately, there was no other option left. And that is the totality which the Election Commission took into account, and took into account percentage, MLAs, MPs, votes polled, and then said, we recognize you as the party. Then, my lords, as far as the conduct is concerned, for instance, my lords, in Rajendra Singh Rana, I'm not distinguishing, but I'm giving instances of 21A. I'm giving instances of 21A. There on 27th of August 2003, 13 MLAs from the BSP met the governor asking the governor to invite the leader of the Samajwadi opposition party to form the government. It was actions like these which are regarded as ex facie voluntarily giving up the membership of the party under 21A. Here the only allegation against me is that under 21, on 21st we held a meeting of which I say I never received any notice. They say we sent you a notice, we haven't received any notice. And the other notice at 5 p.m. the same day. And they say you voluntarily given up the membership of your party because you did not attend a meeting. That's the overt act they're talking about, which goes on and is the basis of the first two disqualification petitions. In Ravi Nayak's case, my lords, there were photographs showing the MLAs of the political party with the opposition party. And they approached the government saying that they have no longer support the original political party. These are overt cases of 21A. Where, when my Lord the Chief Justice yesterday put the question, nothing more requires to be done. But your whole basis of the case is you've not attended 2 meetings, out of which I don't receive a notice and of the other. You hold it an emergency meeting the same evening. And it was in that context on 27th when your lordship said, give them more time to reply to this. To which your lordships are come and told that your lordships have toppled the government. It's the judicial order which led to toppling of the government. In G. Vishwanathan's case, 2 members of the AIDMK were expelled. After that, they joined MDMK. When they joined MDMK, a motion for disqualification was moved. So these are acts of leaving a political party, joining another political party, supporting an opposition party to form the government. Here, the same political party continues. The cabinet ministers were cabinet ministers in the old regime as well. The Election Commission has recognized them as the recognized political party. So this whole split, no merger, 10 schedule, where does it come in? Then, my lords, please come to question H. My lords have H.
Yes.
Are intra-party decisions amenable to judicial review? What is the scope of the same? My lords, from Sadiq Ali downwards, your lordships have said that it is the Election Commission. Of course, the Election Commission's order is subject to judicial review within the known parameters. And your lordships have held that under Article 324 and the symbols order, the power to recognize a political party, the power to recognize a rival faction within a political party is the exclusive jurisdiction of the Election Commission, including interim orders, including awarding interim symbols and interim names, which it did in this matter till the dispute was being heard. And it is the only body which has the necessary requisite expertise and wherewithal to go and look at the larger picture of majority. Not the speaker, not the governor.
16A.
Please, my lords.
Section 16A.
Yes, my lords. Next, my lords, is the question I. What is the extent of the discretion and power of the governor to invite a person to form the government, and whether the same is amenable to judicial review? Well, it's apart from Bomai, Shivraj, etc., which we've already argued, your lordships in Rameshwar Prasad went to the extent of saying that when a majority is claimed merely because the governor is of the view that the majority has been cobbled by illegal and unethical means.
It's a converse case. That's a converse case.
Yes. So I'm saying
There, that's a dissolution of the House by the governor. Because I think, I'm not very sure, I think before a coalition could be formed, the governor dissolves the House. And the plea taken is that if we give more time, there could be horse trading and buying up more legislators to form the government.
absolutely, my lords, but look at the extent to which the Supreme Court goes. It says that, look, a governor is not some autocratic political ombudsman. Those are the words used in Rameshwar Prasad. So you...
Mr. Prasad, it was Bhuta Singh.
Your lordship knows that only too well.
Firstly, according to us, it's a legitimate resolution passed, representations made to the governor. I'm saying even to the extent where the Supreme Court has said that even if you think in your personal view that something was by unethical means, even then you can't refuse a majority government to be sworn in. That's not for you to decide. But here, there is a resolution which is conveyed. 7 members supporting the government have said so. And to that, my lords, their argument was that your resolution that you talked about, and I want to read that resolution to my lords, talks about the leader being changed and the whip being changed. It doesn't specifically say it's withdrawing support. And even the letter to the governor did not specifically say you were withdrawing support. Now, my lords, with utmost respect, the governor takes note of the resolution. The resolution says the leader, the whip are being changed. There is huge discontent amongst the party with MVA continuing, and we are not happy with this coalition with the MVA continuing. Given this fact, given that 7 other MLAs say that we are withdrawing support, if the words in 121 of Bumai Para 121 saying that the governor will use all processes and means to come to a conclusion, if the governor on the totality of it comes to a conclusion that it's a fit case, and I'm not talking about violence, etc., as your lordships rightly said, let's keep that aside. But surely if the leader of the opposition, 7 MLAs supporting the party, and a resolution of the majority of the MLAs within the party says we are not happy, even if that one word, as they said, was not present saying that we are withdrawing support, is the governor not within his rights to come to a decision that this is a fit case where a floor test should be proved by the chief minister? It's not a case, my lord, of someone misusing this process. Someone, just one person walks in and says, I don't have any faith. I could understand that it can't be done lightly. But you have 7 members who are part of the government. You have 34 or 55 MLAs giving a resolution that we are not happy with this coalition. Is the decision of the speaker such that your lordships, in exercise of your lordships jurisdiction under 32 will interfere with it? Is it so bereft of any application of mind? Or smacks of non-application of mind? Please have that, my lords, that resolution which my lord the Chief Justice also yesterday asked me to read, because the letter I had read out. Please give me that resolution. Convenience Compilation Volume 2, PDF, page 55.
Only 50.
My lord, sir, the resolution of 21st of
Yes.
Resolution of meeting of Shiv Sena Maharashtra Legislative Assembly 2019 to 2024. We, the following members of the 14th Maharashtra Legislative Assembly belonging to the Shiv Sena, we are notified as the members of the Maharashtra Legislative Assembly as members of the Shiv Sena Legislature Party. We had unanimously elected Mr. Eknath Shinde on 31st October 2019 as group leader of Shiv Sena Legislature Party. There was free poll alliance between the Bharatiya Janata Party and Shiv Sena Party for the 14th Maharashtra Legislative Assembly 2019. There has been great dissatisfaction prevalent amongst the members of our party, that is Shiv Sena, and our party cadre at large, on account of corruption in the government, administration regarding police posting, corruption by the then Home Minister Anil Deshmukh, who is in jail, and sitting Minority Minister Mr. Nawab Malik, who is also in jail for involvement in underworld Don Dawood Abraham. Apart from the above reasons, our party cadre faced tremendous harassment and distress on political as well as personal grounds from the opposition. Ideological parties who are now a part of the government were using their office and power to undermine the basis and foundation of our Shiv Sena cadre. There is enormous discontent amongst the cadre of our party, Shiv Sena, from forming government with NCP and Indian National Congress, who are ideologically opposed to our party, the Shiv Sena. There has been a compromise on the principles of our party, Shiv Sena, which has been a party with fierce ideological base and was formed for fighting for the rights of local Marathi people. For the last 2.5 years, our party and its leadership have compromised party principles by aligning with contrasting ideologies for the sake of achieving power in the state of Maharashtra. The ideology of our party leader, late Balasaheb Thackeray, was to give a clean and honest government to the people of Maharashtra, and also without compromising on the principles of Hindutva, which was defeated by the first day itself by aligning with the opposition ideologies. Shiv Sena had forged a pre-planned alliance for 2019 assembly elections. They sought the blessing of the voters for this Sena BJP alliance, which the voters accepted and voted in favor of this alliance. After the results were out, the Shiv Sena severed its ties with the BJP and formed an alliance with the opposing parties, which they had fought against the 2019 assembly elections. This act of our party leader had a tremendous negative impact upon the voters and party cadre at large. There was a continuous hue and cry towards the party leadership for the act of aligning with the opposing parties. Ignoring this, the party leadership went ahead and formed a Mahavikas Adi government. For the last 2.5 years, we, the Shiv Sena Legislative Party members, are facing tremendous pressure from their electorate's voters. We, the members of the Legislative Party, as well as all the leaders and workers throughout the country, were facing a lot of humiliating questions from our voters on account of our support to leader of the opposition. Our leader, Shri Balasaheb Thackeray, was always a strong nationalist. We have also been subjected to a lot of criticism for being a part of this corrupt Maharashtra government. In view of the above, the members of the Maharashtra Shiv Sena Legislature Party have met today and resolved. It is hereby resolved and reaffirmed that Eknath Shinde, who was appointed as the leader of Shiv Sena Legislature Party, is and continues to be the leader of the Maharashtra Shiv Sena Legislature Party. 2. It is hereby further resolved that Mr. Bharat Gogable be elected and appointed as Chief Whip of the 14th Maharashtra Shiv Sena Legislative Party. Appointment of Mr. Sunil Prabhu is cancelled with immediate effect. Now, my lords, two things emerge from this. One, it is not a reference to the legislature party. It is a reference to the political party and the disquiet amongst the political party. The only ground taken is that your specific letter to the governor did not specifically, or the resolution specifically mention that you withdrawn or you will be withdrawing support to this government. Now, if the essence of this resolution and the letter written is we have no faith in this coalition government, and independent MLAs are writing to say that we have no faith, they have lost the confidence, is the decision of the governor who has seized of this resolution, who has told that the MLAs have no faith in the coalition government. 7 independent MLAs who are part of the government, with 2 being ministers, writing the same thing, and also the leader of the opposition. It's not, my lords, that the leader of the opposition, what he writes cannot be taken into account. He takes all this into account and comes to a conclusion. The impression is given to your lordships as if the governor has acted without any application of mind or any material on record. This is, according to me, my lords, more than sufficient material in all humility, because at the end of the day, if the principal concern of the governor is majority on the floor of the House, what better indicator of a majority on the floor of the House than MLAs in substantial numbers writing to them to say that we do not support and we have no faith in this coalition government. And it is this with the Yadurappa judgment dealt with. There, in fact, they went a step further. There they said we have no faith in the chief minister of their own political party. Whereas in Yadurappa's matter, there were MLAs of the BJP writing to the governor to say we have no faith in Mr. Yadurappa continuing in that government, and there should be some other person from the party who should lead. And the Supreme Court said they have not said they are forming another political party. They have not said we are supporting another political party. This is not a case to attract 2-1A. Then, my lords, is the next question, which is J. What is the scope of the powers of the Election Commission of India with respect to determination of a split within a party?
This is on para 15 of the J will arise in the other matter which pertains to the election symbols order.
But yes, but now that it's there, may I just take two minutes?
No.
Let's, if we don't want
It is
to go
pending.
that
Why
way,
should
it's
Yes,
pending.
the only thing, my lord, that I wanted to say was that right from Sadiq Ali downwards, it is settled that the Election Commission has the exclusive jurisdiction to decide the issue, and the correctness of Sadiq Ali has not been questioned. The correctness of Sadiq Ali is nowhere questioned.
That you reserve your energy for
Very well. But my lords, one factual thing that I wanted to point out, as far as the governor is concerned, on 21st itself, that resolution was sent to the governor. On 21st itself of June, it was sent to the governor. On 25th, a letter was written to the governor of June saying that our lives are under threat. And even in that letter, my lords, which is at Convenience Compilation Volume 2, PDF page 287, para 2 says, as is common knowledge, we no longer want to be part of the corrupt government of MBA government. All I am saying is, my lords, other than the resolution on the 25th, when we asked for security also, we again reiterate that we do not want to be part of the government. So to say that we never communicated this to the government is to the governor is factually incorrect. Now, my lords,
Mr. Kaul, just for our information, there are 34 signatures on this document resolution. Are any of these 34 members of ministers in the House?
yes.
How many?
At that time or now?
When this was signed, 21st.
How many out of 34? How many were ministers? 8 in total. 8 out. As your Lordship said, I'm not then addressing your Lordship on the last question on the Election Commission issue.
Yes, I think we
I
can.
will not, but
Anyway, that's a law from Sadiq Ali. There's jurisdiction of the EC to.
Not only that, very interestingly, just note, convenience compilation 1, PDF page 82. Ground D of Mr. Subhash Desai's own writ petition 493 of 2022. He says, can I just read that line? Ground D. Because the constitution of a political party under the 10th schedule and the action of the governor legitimizes what is expressly prohibited by the constitution, the governor has sought to recognize what the constitution prohibits. The governor is also not empowered under the law to recognize who is the Shiv Sena. That is the domain of the Election Commission. Admittedly, recognition of Shiv Sena and its leadership has been endorsed by the Election Commission, and there is no dispute whatsoever to a challenge before the appropriate authority. Now, if that is the domain of the Election Commission, and when a petition is moved that there is a rival faction, which is the party within para 15, and the Election Commission now takes a decision on it, and your lordships were addressed for 4 hours on that day to say that Election Commission should not proceed with it, because your lordships are seized of this matter before a constitution bench. Till your lordships dismissed that stay application moved by them. And they said the Election Commission should not go on with them with the same convoluted argument, status quo ante, relates back to the day they were disqualified, thus everything else suffers from the sin of unconstitutionality, and thus the Election Commission should not proceed because any petition before the Election Commission would be tainted by what these MLAs have done.
As a matter of propriety, should the governor have invited Mr. Shinde to form the government?
Manoj, may I with respect say that if a chief minister resigns and a combination emerges in the matter, what is wrong with it? This was a pre-poll alliance also. In fact, the change which came about later was with a party they had opposed all their lives. And this was a pre-poll alliance. If the governor at that stage feels that this combination can form the government, you can't have a headless state of affairs, you can't have no one there. And he asked them to face the floor test. It's not as if the governor after that gave them 20 days. Your lordships are very often even frowned upon that. When a long leeway is given to form governments. He immediately said in a day form prove your majority. Speaker the next day, the government the day after. So my lords, when we are testing the action of the governor, there could be two views. By hindsight, people may be wiser on some issues. But as I respectfully submitted, is this a case? Merely because the petitioner feels the only way out was a vote of no confidence. Which law says so, my lords? From Bomai downwards, your lordships have said floor test is the best way to do it. What was the need for him to ask for the leader of the opposition to move a vote of no confidence? Why could he have not asked the existing chief minister to face a floor test? And why was the chief minister so scared of facing a floor test that he resigned within 10 minutes of the order being passed? Because he knew he did not have the majority. Now, if you can't leave aside your party, that's why I said, my lords, you exclude all those MLAs. You still don't have the majority on the floor of the House. Can such a chief minister have any moral or political authority to continue after that? And today wants all these actions to be annulled. From governor calling a government, floor test, everything to be annulled and status quo ante to be restored. You refuse to face the floor. Firstly, my lords, I respectfully submit, these 39 MLAs cannot be excluded because the day on 27th when the interim order was passed here, firstly, of course, we said it was not based on Nabam, but even I take it was based on Nabam. What was wrong on it, my lords? That was the stated constitutional position it held the judicial field. It till date holds the judicial field. If a bench of this honorable court relies on a constitution bench decision which says that a speaker whose own removal is pending cannot proceed with disqualification, what is wrong with it? If they had recorded that, it was an absolutely valid order. They are questioning now in a reference, but it is still it has held the judicial field. It's the accepted position today of 5 judges of this honorable court. Till your lordships comes to a conclusion that it doesn't lay down the correct law, if at all. So even if the 27/6/2022 decision was based on Nabam, it was only on principles of natural justice. Suppose it was
Another way
based
of
on Nabam.
looking at it also. There's another way of looking at it. Suppose the interim order was not passed on the 27th, which according to them effectively had the consequence of staying the action by the speaker to disqualify these people. and take it at its worst that therefore the speaker would have disqualified these persons. If the speaker had disqualified these persons, they would have ceased to be members of the House. They would individually stand disqualified. Would the governor have still been justified in calling for a trust vote?
Yes.
Because he would have then said that 39 members, 16 plus 22, 39 members have been disqualified from out of the ruling three-party coalition. I still want to have a trust vote. Would he have been justified in doing that? If we say in the affirmative, then you have an answer really of how the voting has taken place,
Right.
excluding these people.
But my lords, 2-1A which they rely on, there is no case of 2-1A made out. Apart from everything else, because I do not attend two meetings.
That's a separate issue, but on the point as to whether this court's order.
Yes, my lords, I bow down. My lords are absolutely
assume for a moment that this court had not passed the order. What would have been the consequence at the highest? The speaker would have disqualified these people, right?
Yes, yes.
If they had been disqualified, then they would have gone out. The speaker would have, the governor would have then called for a trust vote. With the one change that Shinde would have not been called upon to be the chief minister then. Then the governor would have called upon perhaps.
And my lords, to take it forward, there are
the BJP to form the.
There are too many hypothetical assumptions, presumptions on the petitioner's part. So and so would have happened. Thus, this would have happened. Then there's a constitutional saying everything would have been annulled in the process. That's not how.
They are right to this extent that the request to Shinde to become and to swear in Shinde as a chief minister, and the opportunity given to him to establish his majority on the floor of the House on the 30th came into being only because in the meantime the speaker could not disqualify Shinde, because if he had disqualified him, all the 39 would have gone out. It would have not made a difference. The Shiv Sena, probably that coalition wouldn't have come back to power. Possibly, because these 39 go out. But with the 39 going out, the composition of the government today would have been entirely different.
Well, as I respectfully submitted, these are
hypothetical.
Too many hypothetical. But all I'm saying is the speaker could not continue with the disqualification.
Not exactly hypotheticals, because you know what was happening and what would have happened.
No, my lords, what I'm saying is that.
So the speaker was acting in post haste. That's why, the writ petition.
The speaker was acting in post haste in every which way. On the same day, he approves a new leader. On the same day, he says you file your replies within 2 days.
Of course, the 39 would have come to this court and said, well, we have been disqualified without giving us even 7 days notice.
That's why
in which case, stay the order of disqualification is contrary to law.
I wanted to point out
then.
one timeline which is important, which I forgot when I was reading the timeline, and it has some relevance here. On 21st, when the notice to the deputy speaker was sent for removal, on 21st, was sent to the speaker, it was signed by 34 MLAs and it is admitted by the deputy speaker in his actually the chart I gave, quite apart from removing the 39 or whatever the 3 independents, they were actually running away from actuals. 13 of the people who were supporting them also abstained. 16 abstentions were there. 13 of them were their own people who were supporting them abstained.
Came to 99.
That is how they came to 99 on that day.
What are you saying? Sorry.
Please, my lords.
You're saying something?
My lords, the second page, where if your lords were to see the first chart, votes against Mr. Eknath Shinde, 19. This is a 99. These are, my lords, the 13 people of the 16 who abstained. 24 abstained, 13. 13 were from Agadi, the NCP.
Of the 24 who abstained,
Yes.
13 of the other group.
Yes. So quite apart from the 42 being deleted, your own people were not there to support your government. Yes. That is why this number comes to 99.
13 from MBA abstained.
Abstain. So your leave aside disqualification. I have even given charts that if you exclude the disqualified members, still we win. But here are people who are supporting you. Even they abstained. Because you had lost the support. Yes. Yes.
29 is Shinde and 16 is.
I see. I got it, yes.
Now, my lords, just to answer what my lords put to me, my lord, the Chief Justice, to say that Mr. Shinde would not have made it is wrong for the simple reason, my lords, and I say this humility, that A, till he is disqualified, he continues to be a member of the House.
No. What the Honorable Chief Justice says is, if he would have been
But my lords,
disqualified, then in
my lords, but as I respectfully
so he was
submitted,
one of the person against whom the disqualification.
but the speaker could not have gone ahead with that disqualification in view of Nabam Rebia. So how do we presume had he been disqualified, then had he been then all?
Not pressed at all.
Yes, my lords,
He argued according to you.
but my lords, I said so. I said so, and I've been right through saying from the beginning because I argued. I'm not for a minute suggesting I did not argue Nabam Rebia. I did argue Nabam Rebia.
No, but even if you look at it from on a demerer,
Yes.
that suppose Nabam was not there, the consequence of Nabam not holding the field would be that the speaker would be entitled to decide the disqualification notwithstanding the pendency of a notice for his own removal.
Right.
If he had decided the disqualification,
Right.
then these 39 would have gone out.
Right.
In which case, still the government had to fall.
Absolutely.
On the numbers.
That's why I've given the charts with 42. I consciously made these charts with 42, minus 42, and now I'm going a step further. Mr. Jethmalani rightly pointed out to me, he said that these 13 also, the ones who were supporting them abstained. There were 16 abstentions. So whichever way we look, the numbers were not there. And that's why this chief minister, the then chief minister, resigned within 10 minutes because he knew he did not have the majority. And he was not confident to face the floor.
Because he was aware that
He was aware what was happening. So everything we go back to say that because of disqualification, this was fait accompli. You can't even take care of people who were supporting you, the 13.
Mr. Call, you can consider from this angle also. So far as Nabam Rebia is correct, the order dated 27/6. You might have pressed Nabam Rebia. At that time, you might have argued also. And you, according to you, argued also. But this court, correct, did not injunct speaker, correct? Maybe technically till 12th, correct? He was restrained from, it can be said he was restrained. But there was no restraint at all, correct? Against the speaker exercising the powers.
I bow down to it.
If the Nabam Rebia would have been considered by this court, then there would
Then he could not have continued.
Then it would.
Then no proceeding should have been stayed before him. My lords, I said so repeatedly, the entire argument was heard. Ultimately, the court, considering, because the same argument made, there are problems, Nabam Rebia applies, doesn't apply. The court said only on pure principles of natural justice give them more time, because the rules provide for 7 days. And on a weekend, you've given them 2 days. So there was say that your lordship's order was the result. And then your lordships are told because of that, rewind everything.
On the lighter side, everything went so fast.
Well, that is
No,
politics.
no, we are not. That is why it is.
In fact, my lords, that's why in para 78, your lordships say of Shivraj Singh Chauhan, timing on a particular date, what happens, in whose favor, what tilts, that's politics. And they say that's none of the concern of the court. The court, that's what your lordships records in para 78 of Shivraj Singh Chauhan.
You want to show some.
Yes, yes, ma'am. I'm not bothering your lordships with this, but another argument which was made was that even in our notice to the speaker, we had not mentioned anything about majority. There's a specific paragraph in the letter to the deputy speaker that he has lost the majority. So to say that we had not mentioned it is factually incorrect. And as far as notice to the speaker is concerned, my lord, that's the last point before I go to the case law. 21st, I give a notice. The deputy speaker files an affidavit in this court that that notice was received. Secondly, on 22nd of June, a hand-delivered copy is given. On 24th of June, an email is sent to which apparently the speaker comes, and that day Dr. Dhawan appeared. He appeared in court and said that to this, it was not from an authorized email. So we pointed out that there is Rule 18 of the Maharashtra Legislative Assembly rules, which just talks about a signed notice being given. There's no other restriction on it. So even if we exclude the 24th, 21st, we send the deputy speaker accepts that such a notice was given. 22nd, a hand-delivered copy is given with a stamp, which we showed to the court when we went. So he said, what are you talking about not receiving a copy? This is a hand-delivered with a stamp. And on 23rd is the disqualification petition. And that is why, my lords, I said the scope for misuse of disqualification is enormous. And that is exactly what was sought to be done. You knew there was discontent. You knew it was simmering. You knew it reached its culmination on 21st with a resolution being passed at the meeting that overwhelmingly the cadres were not happy with this coalition, and you knew that the next sequitur to this will be a trust vote. You immediately move a disqualification petition, and the speaker on the very same day accepts your person, and then 2 days later I'm told file a reply. It's under those circumstances that I came, because repeatedly your lordships are told constitutional propriety, morality, abuse. If at all there has been abuse in this matter, my lords, it has been by the regime then in power and the then deputy speaker, with the hurry that they moved, that they did not even follow the basic norms of natural justice. If the 7 days were required, what was the hurry in giving 2 days? And the only argument the other side had was that in one of the matters your lordships have held that even 2 days was enough. So I'll also cite 5 judgments to say that 2 days were not enough. Where your lordships have said there's no straight jacket formula, it has to be seen in the facts of every case. That takes us nowhere. But given the facts, what was this great hurry that over a weekend you wanted replies to be filed? That's what led to our 32 being filed. Quite apart from the fact that Quixote was not a bar to us, because Quixote works if you're seized of a matter, speaker is seized of the matter, you don't go to court. Not in a case where Nabam applies, that the speaker has a disqualification pending against him, removal pending against him, and he cannot proceed at all. It was in those circumstances that I came by way of a 32. Now, my lords, I'll come to the case law.
Case law on the point.
Yes, my lords. नहीं यार अभी नहीं रुक जाओ अभी कुछ नहीं देना. My lords, I'll start by distinguishing Mayawati's judgment.
Why don't you do this? You can actually cite the judgments in chronological order and then distinguish whatever they have cited along the way, so that perhaps you can do that in a chronological order. Whichever judgments you are citing, you can cite them chronologically. And then if they have relied on a particular judgment, you can distinguish it along the way. That's one way of doing it. Or you can cite Mayawati.
I thought, my lord, there are 4 or 5 crucial judgments that they relied on for their case.
All right,
and then I'll come to...
All right, fair enough. And then you can cite your judgment.
Yes.
Mayawati is at, where is it?
Convenience compilation, volume, judgment compilation, volume 2.
Well, in fact, if your lordships permit, I'll just very briefly tell your lordships of the facts. I won't bother your lordships with the paras at all. I'll give the facts. I've summed up the facts.
Just give us the reference in the compilation, that's all. So if you have to...
Convenience compilation, volume 2. PDF page 1080.
Citation.
1998.
1998, volume 7, SCC 517. My lords, in 1996, my lords, in the general elections to the UP Legislative Assembly, no political party obtained an absolute majority case. So there was an agreement between the Bharatiya Janata Party and the Bahujan Samaj Party. BSP at that stage had 67 MLAs and the BJP had 175 members in its fold. On 21/9/1997, Mr. Kalyan Singh of the BJP was sworn in as the Chief Minister. On 19/10/1997, the appellant, that is Avati, announced withdrawal of participation and support of the BSP to the coalition government. All the BSP members resigned from the government. Immediately, the governor of the state convened a special session of the assembly at 11 a.m. on 21/10/97, that date is important, and told Mr. Kalyan Singh to prove his majority on the floor of the house. After that, on 28/10/97, appellant issued a whip directing all BSP MLAs to remain present in the house throughout the proceedings on the next date and vote against the motion. That was the whip issued. On 21/10/97, 222 members of the assembly voted in favor of the government. There was no vote opposing it. On 24/10/97, 13 petitions were filed seeking disqualification of those members of the BSP of violating the whip given on 20/10/97, the whip which had been given. And the petitions invoked only clause 2(1)(b) of the 10th schedule. Your lordships may note that the allegation was 2(1)(b) of the Constitution. On 25/11/97, the concerned MLAs against whom disqualification petitions had been filed their written statements and pleaded that a split took place between the members of the BSP on 21/10/97, and more than 1/3 legislators of the BSP got separated, and thus they relied on the protection of para 3 of the 10th schedule. The speaker on 23/3/98 dismissed the disqualification petitions and recognized the MLAs as a separate political party. In this background is what the appellant said, and in this background what the appellant said is that it is the whip which is issued by the erstwhile legislature party of the BSP and not the new political party which had been formed, as used in para 2(1)(d), is the legislature party of the original political party of those MLAs is what is to be read into 2(1)(b). The court said nothing doing. Political party, as mentioned there in 2(1)(b), cannot be read as a legislature party. So this was a split, a new party had been formed and they were bound by the directions of the new party and protected by that.
What were they relying upon in Mayawati in particular? What is the...
That a whip of the legislature party of the BSP of which they were a member before splitting
That is
had told them not to vote.
28th October whip.
Yes, had told them not to vote in favor of the motion.
Right.
So they said you violated the whip of the legislature party. And because you violated the whip of the legislature party, you are disqualified. They said we have split and we formed a new party. And our new original political party told us what to do. We did it in compliance with that. So Ms. Mayawati argued that you read legislature party into 21B and that whip ought to be obeyed of the old party. The court said, no, we will read it as the political party and they are protected by para 3 of the 10th schedule. Now, my lords, in our case, A, there is no rival faction which has split. The rival faction is within the party. No new political party has been formed. The question is not of an erstwhile legislature party of a party that you belong to vis-a-vis the new original political party that you formed. The judgment at no point says that when a whip is whom the speaker interacts with, the whip as appointed as per the rules conveyed by the leader, etc. should be ignored and we should look at some deeper other whip which the political party is appointed. That's not what it says. All it says is, in the given facts and circumstances, that that legislature whip of the party is not applicable because they are protected by the sanction as given, by the formation of the new political party. So Mayawati, according to us, my lords, has no application at all. And in any case, my lords, as I have said, it's never been our case that it's only the legislature party and not the political party. We've right through said both are co-joined, organic, integrated, and any action of the legislature party has the political authority of the political party to say what it says. Now, my lords, Rajinder Rana, Volume 1, PDF page 834.
$834.
Yes. So, my lords, Rana is relied on by them. I relied for a different purpose. They rely on Rana for two essential purposes. One is that it said disqualification is ex post facto. So everything goes back to the date of disqualification. And secondly, your lordships, in an appropriate case, decided the issue of disqualification as a court of first instance rather than remanding the matter or letting the speaker decide. Those are the two grounds taken to rely on Rana. Now, my lords, just some facts. Quite apart from the second issue, my lords, the straight answer would be the matter was pending for 3 years in the High Court. The High Court then remanded it back. The Supreme Court said the assembly elections are at the end of the year. Rather than remanded, decide the matter. Those are peculiar facts, not that in every case you bypass the constitutional authority and come to the Supreme Court as a court of first instance. But on the first part, my lords, some crucial facts. After the 2002 UP elections, my lords, to the UP State Assembly, a coalition government was formed headed by the Bahujan Samaj Party. In 2003, my lords, the cabinet recommended dissolution of the assembly. And now this is important. Before the resignation of the cabinet, my lords, on 27/8/2003, 13 MLAs of the BSP party met the governor and requested him to invite the leader of the Samajwadi Party to form the government. the opposition to form the government. The governor acceded to the request. And thereafter, Mr. Swami Prasad Maurya, who was with the BSP, filed a disqualification petition saying that they had voluntarily given up the membership of the party by supporting Samajwadi Party and going to the governor. On 6/9/2003, 13 members, those 13 MLAs who had gone to the governor with the Samajwadi Party MLAs, fortified by another 24 MLAs, requested the speaker to recognize a split in the party, and the speaker recognized the split in the party. The Supreme Court said that split and to be entitled to the benefits and protection of para 3 of the 10th schedule is an event which happened later. The governor is only concerned with the day when those 13 BSP MLAs met the governor and requested him to invite the leader of the Samajwadi Party to form the government. And the speaker should have only looked at the facts on that day and said not at subsequent events, and in that context said, ex post facto, it will go back to the day they were disqualified or incurred disqualification under the 10th schedule. It could have never been the intent of the court, and it did not say so, that on one hand the Supreme Court says that till disqualifications petitions are pending, you participate in all proceedings. On the other hand, the moment you're disqualified, all your actions are annulled. So ex post facto was specific because the speaker started looking at subsequent events. The speaker started looking at a split which had not happened on that day. And they said this is an overt 2-1A act, where you go to the governor, request him to get the Samajwadi Party to form the government. It was in that context. The other part of Rajendra Rana, I pointed out to my lords that, now my lords, another judgment.
Sir, Paul, why don't you do this tomorrow morning? Just give us in 2 pages a small note on how you distinguish each of those judgments.
Very well, very well.
Isn't it?
No, I'll do that. I'll get for all those 4 or 5 judgments
That's right.
a distinguishing note tomorrow.
Just 2 or 3 pages.
Yes.
There's a bullet.
And what I'll do, my lords, tomorrow is I have also prepared a written note of the various propositions and judgments that I'm relying on.
Right.
I'm in the process. I'll take your lordships through that. And wherever your lordships wants me to really read any particular paragraph, I can do that.
All right. That will be much quicker then. Yes.
If
Faster.
just
Now,
to
just so that you know, how long would you take? Will you finish in about an hour or so tomorrow?
yes,
So we target starting by 11 o'clock tomorrow. So 12 if you finish. Then between Mr. Jethlani,
What I'm respectfully submitting.
if you can, Mr. Jethlani and Mr. Maninder Singh, if you can give us a brief note of a page or so.
I was about to say that, Malad, to remain within the time discipline, Malad, we'll furnish a note by today evening. And Malad, very 10-15 minutes, Malad, we'll just make your lot.
If both of you can just give us, email the note to the courtmaster, so he'll circulate it in the night to us and give it to Mr. Sibal, because Mr. Sibal will also be then.
Try to finish before.
And you can also email
The problem is the
Sibal.
Solicitor General is to argue. Please remember that.
Yes, of course.
So-
Now, what about the solicitor? So maybe, Mr. Kaul, is it possible for you to sort of complete by say 11:45? Say we start at 11 because we have mentioning. If you can try and compress it by 11:45,
Try my
then between Mr. Jethlani and Mr. Maninder Singh by 12:15, that leaves 45 minutes to the Solicitor General. If we can do that, we entirely with.
We'll try our best, as succinct as we possibly can be. We'll try.
Because otherwise
that-
it will be
Right.
difficult.
well, otherwise the rejoinder could be
difficult for us.
restricted to 1 hour. They've argued for 3.5
Otherwise
hours.
it will
my
be
lords.
difficult. If they don't finish by 1 o'clock.
Rejoinder only depends upon how the other side is.
Then 1.5.
What the other side is.
So how long was the solicitor likely to take? Any idea?
He said 1 to 1.5 hours to me.
So
1 to 1.5 hours to me, he told. He told that.
All right, try and make your arguments as compared. But we'll wrap up with this side by lunch so that, yes.
the first we'll sit down.
No, it's
Within
not
the
like that.
time-
We just,
The one
because,
thing-
only because we are heading
the
towards
one
a
thing-
week-long break, and we don't want to keep this beyond the break. That's the
The one thing the learned Chief Justice is he never gets tired of anybody. He never shows it at least.
That's the theory of it.
No, but that's a fact in my mind as well, because,
I know.
if you have an understanding about how vast the field of knowledge is, you can never tire of the arguments which lawyers were in before.
We've
Because the
noticed
last word is never said until the last word is over.
That's correct. That's correct. And I hope we have.
Very
the last
grateful,
word.
man. Very grateful.